Okay, I see something that says we're now streaming live on YouTube.
Yep, we're
So,
good to go.
Alan, if we can go on the record, please. Good morning. Today is the first day of remote evidentiary hearings being held by the Energy Facilities Siting Board in dockets EFSB 20-01, D.P.U 20-56, and D.P.U 20-57. Those are Vineyard Wind LLC's 3 petitions to the Energy Facilities Siting Board and the Department of Public Utilities for approval to construct and operate a proposed project consisting of an underground transmission cable consisting of approximately 27 miles of underground 115 kilovolt onshore cable and approximately 23 miles within state waters of subsea offshore 220 or 275 kilovolt cable, a new substation in the town of Barnstable, and an approximately 0.7 mile 345 kV underground transmission line between the new onshore substation and the existing West Barnstable substation. Collectively, we will refer to these as the projects. The onshore portion of the proposed project would pass through state waters in the towns of Barnstable, Edgartown, Mashpee, and Nantucket, Massachusetts, and make landfall in Barnstable. The onshore portion of the project, including the landfall, will be located entirely in the town of Barnstable. My name is Donna Sharkey. I am the presiding officer in this proceeding and am replacing presiding officer Kathy Cedar. I apologize for any delay in the schedule that we've incurred recently, but we will move forward with a rescheduled hearing and witness list that I distributed to the service list last Friday. I will be in charge of the proceedings and any additional procedural matters going forward. My contact information is presented in the updated service list and the emails that I've sent out to all of you. We are conducting these evidentiary hearings remotely using Zoom video conferencing. As you can see on your Zoom video stream, there are a number of others with me from the Energy Facility Siting Board who will be involved in the review of this project and who are participating on our virtual bench today. I'll ask that they raise their hands in their Zoom window when I identify them. As follows: Dean Hazel, Assistant Director of the Siting Division; Wayne Wang, an Energy Facilities Siting Analyst with the Siting Division; and Joanna Yellen, an Energy Facilities Siting Analyst. Andy Green, Director of the Division, and Joan Foster Evans, General Counsel of the Division, also are attending the hearing today. Counsel and company representatives for Vineyard Wind, as well as counsel for the interveners and the interveners, also are participating remotely on this Zoom event. These hearings are being recorded and available for viewing on YouTube. Parties should be aware that the official transcript of the proceeding is the transcript recorded by the reporter appointed by the Siting Board for that purpose. Before we move on, I'm going to outline some guidelines to use in speaking at this hearing. There is a court stenographer who is participating remotely who will transcribe everything said during this hearing. As we are all relying on the internet or telephones to participate, we could experience some technical difficulties, such as sound from speakers, including background noise, video and audio issues, and potential delays. Therefore, it is imperative to speak slowly and clearly, to allow a speaker to finish speaking before you begin speaking, and to pay attention to the video of the person speaking and my video. I will raise my hand as a signal on my video if I need to interrupt the person currently speaking to ask them to stop. It is also helpful if you mute your audio when you are not speaking to reduce any background noise. We appreciate everyone's cooperation in participating in this proceeding. I apologize in advance for any technical difficulties that we may encounter through the course of this remote hearing. Please let us know if you are having any difficulties. If you have problems, please raise your hand using the Zoom toolbar. If you are participating by phone and cannot use that feature of Zoom, please text 781-910-4966 for assistance. With those directions concluded, I would ask that the counsel for each party make an appearance for the record, beginning with the counsel for the petitioner Vineyard Wind, and identify themselves, their business addresses, and the party for which they are appearing at this time.
Good morning. My name is Adam Kahn. My business address is Foley Hoag, 155 Seaport Boulevard, Boston, Massachusetts. I am appearing as counsel to Vineyard Wind in these proceedings. And my colleagues will introduce themselves.
Good morning. My name is Zachary Gerson. I'm an attorney with Foley Hoag, the same business address, 155 Seaport Boulevard, Boston, Massachusetts, appearing on behalf of Vineyard Wind.
And Aaron Lang, also Foley Hoag, also at 155 Seaport Boulevard, appearing on behalf of Vineyard Wind.
Then could we move on to Eversource, an intervener in this proceeding? Kathy, you're on mute.
Good morning. My name is Catherine Cuthan. I'm appearing on behalf of NStar Electric Company, doing business as Eversource Energy. I'm from the law firm of Keegan Worlin, and my business address is 99 High Street, Boston, Mass. Also appearing on behalf of Eversource Energy is Lisa Luftig, senior counsel at Eversource Energy Service Company. Her address is 107 Selden Street, Berlin, Connecticut. Thank you.
Thank you. Mr. Eugenio?
Morning, everyone. I'm Jeff Eugenio. I represent Mark Axelson, an intervener in this case. I'm of the firm Gellerman and Cabral. We are at 6 Beacon Street in Boston. And Mr. Axelson, he resides as a home at 861 Craigville Beach Road in Centerville.
Thank you. And Ms. Dalmas?
Yep. Good morning. My name is Victoria Dalmas. I'm an attorney. I represent Jacqueline Johnson, an intervener in this proceeding. And I am with the law firm Semi and Associates, 15 Cape Lane, Brewster, Massachusetts.
Thank you.
You're welcome.
Are there any procedural matters that we need to discuss before we begin? Seeing none, I believe that Eversource filed a motion on June 25th, 2021, requesting protective treatment for certain information contained in the attachment of its response to information request EFSB-ES-10 in the second set of information requests from staff to Eversource. Eversource has identified the information as critical energy infrastructure information as defined by the regulations of the Federal Energy Regulatory Commission and as may be eligible for protective treatment under certain provisions of the Massachusetts Public Records Law. Eversource requests protective treatment from public disclosure in its motion, although parties may receive such information who execute a non-disclosure agreement. Do any of the parties object to Eversource's motion?
No.
In that case, I will take the motion under advisement and allow us to proceed by treating that information as protected information consistent with the company's motion while that ruling is pending. Is there anything else we need to address before we begin? Once Vineyard Wind begins its direct examination of witnesses, staff will begin its questioning on a specific topic. Next, interveners may proceed with any questions, and then we'll provide Vineyard Wind the opportunity for any redirect. We will proceed in this order for each topic. We expect the hearings generally to run from 10 to 5 o'clock each day, but may conclude earlier if necessary, and we will take breaks. We will move on to the company's presentation of its witnesses for its direct case. When counsel is ready, please identify your witnesses and I will swear them in.
Yes, presiding officer, we are ready. Our witnesses are Jack Aruda, Chris Rodstrom, Ted Barton, and Holly Carlson Johnson.
Could the witnesses raise their hands so I can see their right hand in their window screen? Do you solemnly swear or affirm to tell the truth in this proceeding?
Do.
Mr. Barton, you're on mute.
I do.
Mr. Ruda, I don't think I heard you, but I'm sure you spoke.
I do.
Thank you. Then the company may proceed to identify its witnesses with their business addresses and present their direct testimony.
Thank you, presiding officer. I'll begin with Jack Aruda. And so, Mr. Aruda, if you could please state your name and business address for the record.
Jack Aruda. I work for Vineyard Wind at 700 Pleasant Street, New Bedford, Massachusetts.
And in what capacity do you work with Vineyard Wind?
I'm the technical development manager.
And are you testifying on behalf of Vineyard Wind in this proceeding?
I am.
Was your resume submitted as attachment 1 to the witness list that Vineyard Wind submitted in this proceeding?
It was.
Have there been any material changes to that resume since its submission?
They have not.
And did you participate in the preparation of Vineyard Wind's submissions in this proceeding, including the analysis to Vineyard Wind's petition, which has been marked as exhibits VW1 and VW2, the draft environmental impact report for the Vineyard Wind Connector 2, which has been marked as exhibit VW7, and information request responses that bear your name as a responsible witness?
I did.
And were those information request responses that bear your name prepared by you under your supervision?
They were.
And do you have any changes to those materials at this time?
I do not.
Do you adopt those materials as your testimony in this proceeding?
I do.
Mr. Rodstrom, if you could state your name and business address for the record.
Chris Rodstrom. I work for Vineyard Wind at 700 Pleasant Street, New Bedford, Massachusetts.
And in what capacity do you work for Vineyard Wind?
I'm the technical design and permitting manager at Vineyard Wind.
And you're testifying on behalf of Vineyard Wind in these proceedings?
I am.
Was your resume submitted as attachment 2 to the witness list that Vineyard Wind submitted in these proceedings?
Yes, it was.
And have there been any material changes since its submission?
No, no changes.
And did you participate in the preparation of Vineyard Wind's submissions in this proceeding, including the analysis to Vineyard Wind's petition, which has been marked as exhibits VW1 and VW2, the draft environmental impact report for the Vineyard Wind Connector 2, which has been marked as exhibit VW7, and information request responses that bear your name as a responsible witness?
Yes.
And were the information request responses that bear your name prepared by you or under your supervision?
Yes.
And do you have any changes to those materials at this time?
No, I do not.
Do you adopt those materials as your testimony in this proceeding?
I do.
Mr. Barton, could you please state your name and business address for the record?
Certainly. Theodore Ted Barton. I'm at Epsilon Associates, 3 Clock Tower Place, Suite 250, Maynard, Massachusetts, 01754.
And in what capacity are you employed by Epsilon Associates?
I'm a founding principal of the firm.
And on whose behalf are you testifying in this proceeding?
Vineyard Wind.
And was your resume submitted as attachment 4 to the witness list that Vineyard Wind submitted in this proceeding?
Yes, it was.
And have there been any material changes to that resume since its submission?
No, there have not.
And did you participate in the preparation of Vineyard Wind's submissions in this proceeding, including the analysis to Vineyard Wind's petition, which has been marked as exhibits VW1 and VW2, the draft environmental impact report for the Vineyard Wind Connector 2, which has been marked as exhibit VW7, and information request responses that bear your name as a responsible witness?
Yes, I did.
And were the information request responses that bear your name prepared by you or under your supervision?
Yes, they were.
And do you have any changes to those materials at this time?
I do not.
Do you adopt those materials as your testimony in this proceeding?
Yes, I do.
And Ms. Johnston, could you please state your name and business address for the record?
Sure. Holly Carlson Johnston. I work at Epsilon Associates at 3 Milland Main Place, Suite 250, Maynard, Massachusetts, 01754.
And in what capacity are you employed by Epsilon Associates?
I am an associate with the firm.
And on whose behalf are you testifying in this proceeding?
Vineyard Wind.
And was your resume submitted as attachment 9 to the witness list that Vineyard Wind submitted in this proceeding?
It was.
And have there been any material changes to that resume since its submission?
No, there are not.
And did you participate in the preparation of Vineyard Wind's submissions in this proceeding, including the analysis to Vineyard Wind's petition, which has been marked as exhibits VW1 and VW2, the draft environmental impact report for the Vineyard Wind Connector 2, which has been marked as exhibit VW7, and the information request responses that bear your name as a responsible witness?
Yes.
And were the information request responses that bear your name prepared by you or under your supervision?
Yes.
And do you have any changes to those materials at this time?
No, I do not.
And do you adopt those materials as your testimony in this proceeding?
I do.
Thank you. Presiding officer, the witnesses are now available for cross-examination.
Thank you. Mr. Hazel, would you care to begin with questions from the bench?
I would. Thank you, Ms. Sharkey. Good morning, everyone. Ms. Sharkey introduced me already, but just for starters, when I ask a question, generally speaking to the whole panel, and whoever feels they're most appropriate to respond, feel free to speak up. There may be certain instances when I direct a question specifically to one witness, but I'll let you know if that's the case. On Thursday night, the company filed exhibit VW10, which is an update to the substation's design. And before we get going on our regularly scheduled topics, I'd like the panel to kind of walk us through what's the scope and purpose of the substation design updates.
Mr. Hayes, I'll be glad to start it off. The filing that we made describes a change primarily to the access to the substation at Chute Flying Hill Road. We were able to secure an option to purchase an additional parcel of land to the east of the proposed substation site that allows us to change the major construction and heavy equipment and emergency access to the site and provide some improvements, we think, to the design by locating that access point at the new location. It allows for the major construction and equipment to be brought into the site further away from the residential abutters to the east, to the west of the substation. And it also allows us to greater flexibility in modifying the substation final grade to lower the site by some degree, reducing the amount of material that would either be removed from the site or brought into the site, as well as lowering the overall visibility of the site in some degree. So we do feel it provides some improvements to the location and access into the site.
So you indicated that the company has an option agreement to purchase. I've been referring to it as the triangle parcel, but I believe it's 6 Shoot Flying Hill Road. Is that the correct address?
That's the correct street address, and it is largely triangular. Yeah.
Okay. And when I look at that parcel on Mass GIS, it actually looks like there's sort of 2 parcels labeled as 6 Shoot Flying Hill Road, which together make up a triangular shape. Is that familiar to you, or is that an oddity on the Mass GIS system?
Yes, you're correct. It does show up that way. We have had a title run on the property, and both of those parcels, as shown in Mass GIS, comprise the single property triangular parcel that we have optioned and that constitute the area that is being added to the substation design. And
I believe the exhibit VW10 indicated that Mass DOT, the Massachusetts Department of Transportation, has I think it might be referred to as an option of right of first refusal or something like that, where they have the opportunity to purchase it first. Is that correct?
That is correct. In the deed, to the property, there is a retained right to the Commonwealth, to Mass DOT. And
how is the company working to resolve that property interest from Mass DOT?
We are working together with the property owner, the Cape Cod Chamber of Commerce, to resolve that. And there's been some good progress made in that direction, and we're optimistic it will be resolved.
Do you have a time frame, Mr. Rodstrom, in which the company expects that issue would be resolved?
I think the early indications are that it could be resolved in the coming weeks or couple of months. I think the initial indications were positive, but we understand there are certain procedures that will have to be followed, and we don't yet have clarity on exactly how long that will take.
Can you tell me if the company is able to secure ownership of the parcel? Is the company seeking to obtain a zoning exemption for this parcel as well?
And I will defer to my colleagues at Foley Hoag, but I do believe as part of the substation design, we may be seeking that. The primary purpose is a access road at this point, but perhaps I could defer to either Attorney Gerson or Attorney Khan on that point.
Well, perhaps the easiest way to deal with that particular issue at the moment is if we issue our first record request of the day, which would be for an appropriate representative from the company to provide a statement as to whether they intend to seek a zoning exemption for the new parcel that they're seeking to potentially add to the project. That would be EFSB RR-1.
Ms. Sharkey, it might be appropriate to add a follow-up question on that. It would be, how procedurally would the company like to secure those zoning exemptions as part of this proceeding? Just so that we understand the company's approach for doing so when we evaluate a path forward.
And we'll include that within the scope of EFSB RR-1.
May I add to that record request also, please?
Of course.
Yeah, and would the company or company's attorneys opine on whether or not the company needs to own the land in order to seek the zoning exemption? Or could, if there were a zoning exemption sought, could it happen prior to the company closing on this parcel of land. Thank you.
And that too will be included in E EFSB RR1.
You know, the siting staff are very interested in this, you know, update to the update to the substation designs. We might have like a number of record requests sort of flowing out of Exhibit 10. Mr. Rodstrom, it sounds like from your previous statement that the company may close on this property after the conclusion of evidentiary hearings. Is that correct?
So I think the option that the company has secured allows for a duration of time before closing up to and through financial close of the project. So I think the timing of closing on the purchase of the property is still not yet been determined.
To me, correct me if I'm wrong, but I believe the you know, redesign of the substation, you know, lowering it to a lower grade, is that contingent on owning that triangular parcel?
The addition or ownership of the triangular parcel allowed us to proceed with a reevaluation and a redesign of the finished grade, as well as improving access, as I had mentioned. So that was the trigger for our re-examination of the finished grade of the site. And it did allow for that to occur, since the access point into the substation could occur further south off of Chute Flying Hill Road at a suitable grade.
So if the company is unsuccessful in, you know, ultimately securing the triangular parcel, would Vineyard Wind need to, you know, proceed with the original design of the substation, which is basically at grade with Chute Flying Hill Road?
Yes, that's correct. That would be our intention, and we do feel that the design as presented in the DEIR and previously filed with the petition is you know, a solid design can be built and accomplish the needs of the project for a substation site. And we view this late addition, and we do apologize for the late notice on this. We were working to try to get that in as soon as possible, but we see this as a modest enhancement to what is already a viable design.
Mm-hmm. So I'd like to ask a second record request that the company notify the siting board when you've successfully acquired that parcel, and when the company would know with a high degree of certainty that Vineyard Wind will proceed with the revised substation design. Does that question make sense?
Yes.
Okay.
That would be EFSB record request number 2.
Could I ask a quick follow-up? Hi, good morning, everyone.
Sorry,
Mr.
who's, oh, that's Wayne. Thank you.
Okay, yep.
Mr. Rodstrom, you said that you might not be able to figure the agreement out until after project financing. Do you know what timeline that is?
Oh, let me clarify that. I expect that we will be able to resolve the existing title issue well before that, and in a much shorter order. And if that title issue were resolved, we would continue with our due diligence on the site. But that was the only major issue that we had identified as creating a potential problem, a significant problem. And that once we have resolved that title question, we would be proceeding with this revised design as submitted with Vineyard Wind 10.
Thank you.
So that would be EFSB record request number 3. in terms of clarifying the company's statement, clarifying when its intent would be to proceed with with the new design that they've presented because of the finalization of the issues surrounding the title.
A few more questions on this topic before we moved on to our regularly scheduled events. Exhibit 10 states that a full 10-foot reduction in elevation is the maximum reduction currently being considered. I'd like the witnesses to elaborate on whether the full 10 feet is the most likely design or whether the company would settle on something less than 10 feet of a grade reduction.
Sure, I could start off. I think we intend with that 10-foot reduction to provide a kind of a maximum grade reduction that could be accomplished with this new access road and additional parcel. I think the company would continue to work towards a design that optimizes a finished grade that limits the amount of material that would need to be exported from the site or imported from the site, potentially to have a neutral fill goal where the material on the site could simply be regraded and reutilized and find a finished grade or result in a finished grade that is between the current proposed grade and this 10-foot reduction you're referring to. But at this point, we just wanted to be able to provide the kind of boundaries of the maximum reduction. But I think the goal would be to further refine that and optimize a finished grade that provides for the best, least impactful substation design.
Is it possible that the least impactful substation design would not optimize the amount of fill that would need to be imported or exported? You know, like say the visual or the noise impacts would be better for minus 10 feet, but the fill would be better for minus 6 feet or something like that. Do you follow what I'm saying?
Yes, I do. Let me see if I can, let me try to answer that. I think as we stated in the Vineyard Wind 10 submission, the 10-foot reduction would maintain the noise levels as modeled as in the substation design submitted with the DEIR. And there would be that any kind of optimization, if I could use that term, of the finished grade would only be advanced if it similarly maintained those same noise levels and at or below currently modeled levels. And similarly, I think the kind of optimal finish grade would also be would result in visual impacts that were no greater, but certainly the goal would be improved from the originally proposed group substation design in the DEIR.
Mm-hmm. I do have a couple of sort of follow-up questions on the noise issue of lowering the grade of the substation. And I don't know, perhaps Mr. Barton could respond to them, or the company can take them as a record request. But is it correct when the company conducts its noise modeling that the elevation of the sources and the elevation of the receptors they're all part of the inputs to the model? Is that correct?
Yeah, yes, that's correct. And those are Those are inputs along with obviously the equipment arrangement, which is not changing, the size and power rating of the equipment, which is not changing. In this case, the use of barrier walls, which in many cases have multiple purposes, but they certainly have an effect on reducing offsite noise levels. And then obviously, lastly, distance from the equipment to the receptors we've modeled, which are a mix of residences in different directions, facilities like the Cape Cod Chamber, and so on. So your question of does the relative grade enter into the modeling? Yes, it does, but it's to some extent a second order effect in and amongst all the other things I just talked about.
So that, I mean, in Vineyard Wind 10 or possibly one of the supplemental requests that were filed, the company asserted that the results of the noise model wouldn't change, or that the noise wouldn't be greater than. So can you elaborate, what that assertion was based on?
Sure. So we did, as we started to examine the possibility of reducing the facility grade, we did exercise the noise model to make sure that we were not going to be increasing modeled offsite noise levels. So we did enough work to assure ourselves that within the range of grade changes we're talking about, that we can live with the modeled levels that were presented in the DEIR. And that holds for up to and including the full 10-foot grade reduction, which, as Chris explained, is sort of the outer limit of what we're looking at.
And did to maintain the noise levels as the grade elevation is lowered, is the company needing to change things like the noise barrier heights or any other mitigating factors as the grade is lowered?
Yeah, so if you went to the full 10-foot grade reduction, we included in that modeling a 5-foot increase in the height of the long wall that runs essentially parallel to the west side of the site. So that wall, as you probably recall, was a 30-foot high structure, and that west running wing or piece of it is now 35 feet. And we also examined the possibility of adding a much shorter barrier on the order of 10 feet down at the southeast corner of the site.
Yeah, I think, for a staff to adequately evaluate the full grade change, I'd like to ask a record request that the company, submit an update to its noise modeling report, which actually shows the noise modeling reports and the requisite mitigation factors that sort of back up the testimony that Mr. Barton offered, that the noise modeling results don't change. So, specifically, I would like to see the noise model rerun and have the resulting output tables of what the maximum increase over ambient noise levels would be.
Okay, and just to be clear, you're essentially looking for the same presentation that we had in the DEIR to be replicated, but for the maximum 10-foot grade change.
That's correct.
Okay, we can do that.
That'll be record request EFSB 4.
I guess also on the topic of the DEIR and sort of the grade changes, I've noticed when I look through the version of the DEIR that I have electronically, figure 2-14 is sort of like the substation schematic, which shows proposed grade elevations. In the DEIR, that figure is like quite blurry and difficult to read. And then in Exhibit 10, the company submitted a very crisp, engineering plan. So I'd like to ask that the company submit an engineering substation schematic of the DEIR substation design that is has a similar level of detail to what was submitted in Vineyard Wind 10, and is also that crisp, easy to read output from the CAD software or however the company produces those maps. Do you follow my request there?
We do, and we were not intentionally attempting to provide fuzzy graphics. So if we did, we can certainly get you an easy on the eyes version.
Yeah, I appreciate that. No problem.
That will be record request EFSB-5.
And I believe Ms. Yellen has a few questions along the same lines as what I just offered, but pertaining to visual impacts of the substation.
Joanna, you're on mute.
Thank you, Mr. Hazel. Given the company's updated substation design, I'd also like to ask for an update on several of the visual IRs and visual simulations. I'm going to provide, this might be best formatted as a record request. I am going to provide some examples. This is not an exhaustive list, but just to give you an example of what we're looking for some updates. So if you could please provide an update to the line of sight profiles in EFSB-V-10, Appendix C of the visual simulation report, and please provide an update to the qualitative descriptions that are outlined in EFSB-V-12. So there might be others, but that's an example of some updates that we're looking for.
And the visual simulation report that Ms. Yellen referenced, I believe, is Exhibit VW8. Correct me if I'm wrong.
Correct.
So we can do that. I would ask that we might be given a little more than the customary 5 days to turn that around, because those simulations, as you can imagine, take some time to put together. So we'll do them as quickly as we can, but likely not within 5 days. It might be more of a 2-week turnaround.
So the operative date is August 2nd, when we're scheduled to cross-examine on substation visual impacts. So that's a full 2 weeks out, and it'd be great if staff could have a few days with the report so that we can digest it before needing to ask questions about it in greater detail.
Understood, and I think that's a perfectly reasonable request, and we will certainly do our best on that.
So it will be record request EFSB-6 for the updated information responses and visual simulations requested by Mr. Hazel and Ms. Yellen. I would ask Mr. Barton that you update us as it gets closer to the anticipated date, if there are going to be any additional delays, and if possible, to at least provide the information that is available by August 4th on that date, before that date.
Understood.
Thank you.
And finally, before we move on to the previously scheduled topics, the company provided a number of updates to information requests, I think, for visual, zoning, and noise. None of the magnetic field information requests were updated, and the company's filing didn't comment on whether changing the grades of the substation would have any impact on the resulting magnetic field. So could you just elaborate a little bit about whether, the maximum reduction of 10 feet would have any impact on the resulting magnetic fields from either the lines coming in or the substation equipment itself?
So that's a good question. And we did have a discussion with Dr. Wahlberg and Dr. Long at Gradient, basically to ask them for their opinion as to whether grade changes in the range we're talking about would have any measurable effect on the magnetic field modeling that has been done, and in particular for the isopleth modeling that was done for the entire substation. And their opinion was that within that range of grade change, no, but we can certainly confirm that.
I think that would be appropriate. So I'll ask another record request that the company's EMF consultants, provide an update on whether the grade change affects the resulting magnetic fields. And even if the answer is it doesn't, we'd like to have enough detail that we'll be prepared to cross-examine on it when that topic is scheduled.
Okay.
So that would be record request EFSB 7.
I think we may have broken a modern day citing record for record requests before 11 o'clock on the first day of hearings.
I do feel a little bad, but I'm all set on the sort of introductory, questioning on the substation redesign. So if no one else has questions on this topic, I'll turn it over to Mr. Wong for project need.
Thanks, Mr. Hazel. Good morning again, and want to reiterate what Mr. Hazel said about the questions that we ask. I'm going to direct my questions at the panel, and anyone that feels like they can answer best should feel free to speak up. I do have a follow-up for the Mr. Hazel's question. Mr. Rostrom and Mr. Barton, you mentioned that the 10-foot decrease in elevation is sort of the maximum that's possible. So are you, is it correct to say that that's less likely? Like, is it likely to be a uniform 10-foot decrease, or is that more of like at the outer realm of what the likely decrease in elevation for the new design is?
Well, I think that is the kind of the outer bound of what the elevation decrease would be, and I think the intent of the company is to finalize a proposed finished grade between the current DEIR substation design and that 10-foot maximum grade reduction. But there are clearly some benefits to finding a point between the two that would minimize the amount of material that would have to be exported from the site, and to optimize some of the factors we were just talking about. So I think the best way I would treat that is as kind of a maximum, but that we are likely to optimize it to some point in between.
Thank you. Yeah, I just wanted to make sure that we don't end up with a description of the new site if you're able to get the new property a description that's less impactful than it actually is. That's sort of where I was going with that. But I understand that you're not going to have that nailed down quite yet. But thank you for the response.
Okay.
While we're on the topic of changes to the project design, I wanted to start with a general question on, because it's been a while since the filing, and we, as the citing board staff would like to know if you can walk us through any other major changes to the project design that have happened since the initial filing. I understand the DEIR is slightly different from the initial filing. So if you can, could you walk us through the major design changes since the filing with the EFSB?
So I could maybe start with that, and Chris and Jack Aruda might want to add to it. But so we're going at this point back about a year in project history. So I would say some of the significant things that come to my mind is we've continued to work on the issue of the most appropriate voltage to use for the onshore cabling, and this has been the subject of a bunch of interrogatories, and it was also spoken to in the DEIR. But basically, when we made our filing, we said we would use either 220 kV or 275 kV underground cabling for the land portions, and we have continued to progress that analysis, and at this point, I believe this was reflected in one of the recent interrogatories, that we have decided to move forward with the 275 kV option, with a few caveats, provided that it's available in the market, that there's the proper testing data to back it up, et cetera, et cetera. But that has certainly moved forward. We've also done some further thinking around the Centerville River crossing, and I believe back when the petition was filed, we had a pretty extensive list of options that we could use for that crossing, and they ranged from HDD, microtunneling, a pipe bridge, a bridge replacement, a longer version of a drill. There were a host of possibilities outlined, and we have continued to progress that work. And at this point, we are focused on the microtunneling as what we think is the best approach at that particular site. And we have specifically dropped the bridge deck replacement option, basically because the town felt that the traffic impacts of that were more than they cared to entertain. So we have some better clarity on that. We've as we just talked about, we've added this 1 acre triangular parcel, or hope to add this 1 acre triangular parcel to the substation, which will enable us to make a better access road approach into that site. So I think those are the major changes that come to my mind, but I probably have forgotten one or two. So I don't know if Chris or Jack, you want to add to that?
Can I interject quickly? Mr. Barton, you seemed focused on saying that the 275 voltage was selected for the onshore portion. Is it true that the offshore portion, at least starting at the offshore substation, would be the same voltage?
Yes, and I should have said that. So.
And if I could just interject briefly on the point of cable voltage. One of our information request responses did touch upon the topic of 275 kV now being the selected voltage. That's PA-5, just for your records, if that's helpful.
I could just expand a little on my colleagues. I would say not necessarily under the category of design change, but I think design refinement that the company has advanced on multiple fronts. The survey and study of the significant and more challenging aspects of the project. For instance, we've completed a geotechnical campaign looking at the nearshore HDD location, landfall, river crossing, some portions of the road and substation. And that geotechnical data and analysis is informing our electrical design and further work on the overall project design. Similarly, we've conducted, in fact, next week, we're conducting further archaeological surveys of key locations along the site that have been identified as potentially sensitive. So working through our consultant, and we're doing field testing of those locations to get a better assessment of how the current design is submitted is actually working out with field data. So I think the combination of geotechnical information, archaeological investigation, and advancing our electrical design on multiple fronts, I think gives us greater confidence in what was proposed in the original petition, and that it including the Centerville River crossing, and that it is remains a very robust and viable design.
Thank you. While we're on the subject of archaeological exploration of, surveys, is this related to when the company says that it's speaking with local Native American tribes to figure out if there's any infringement on archaeologically sensitive items?
Yes, and in fact, we just yesterday we had a workshop with the Mashpee Wampanoag and Aquinnah Wampanoag tribes, as well as invitations to the other federally recognized tribes as part of our federal permitting process. And I think it's accurate to characterize as we have a kind of ongoing dialogue with representatives of the Native American communities, and have been actively soliciting their input on the project. They have been out. A representative of one of the tribes was out observing our geotechnical borings at Craigville Beach, and that for all field work they are invited to participate and to observe at those locations. So that those invitations to participate and to be involved are an ongoing part of our archaeological work. But we are also having kind of broader consultations with the Native American tribes over the project as a whole.
So, Mr. Rostrom, you mentioned 3 or 4 tribes. Are those the extent to which you've been in contact with, or are there more that are just not involved in this particular process?
Through the federal permitting process, we are engaging there are 7 federally recognized tribes that are included in our outreach. So that includes the Mashpee Wampanoag and the Aquinnah Wampanoag in Massachusetts, but also tribes in Rhode Island, Connecticut, and Delaware.
Thank you. It has recently come to my attention that there are also state tribes that might not be federally recognized. Does the company have any recognition of these tribes?
Well, I would characterize it as not recognition, but we certainly are in communication with, for instance, the Chappaquiddick Wampanoag clans, and we have had numerous discussions with them, and they are part of our regular outreach efforts to the Native American communities.
Thank you, Mr. Rostrom. Finally, if you could you quickly provide a summary of the concerns of this group, the Native American tribes, that they have on the project, be it construction or operation or down the road? Or if this is a little difficult now, we can take that as a record request as well.
Well, I could I could certainly start. I mean, I think the what we've heard in our discussions with different Native American tribes and individuals are the potential presence of culturally significant artifacts along the route and in the locations that we're proposing to install our facilities. And so they have provided input on areas that they would like us to make sure to focus on and include in our investigations at an early stage, as well as continue to involve them throughout the project and through construction. So I think that that is one area. And then similarly offshore, I think the offshore export cable route and their interest in the location and the extent of the cable installation efforts and the intersection with paleo landforms, for instance, in the subsea environment, are areas that they are concerned about and that we are actively studying and including in our survey work, and also it's involved in our Section 106 work through the federal process.
Thank you. That sounds like you have a pretty good hold of what the general topics are. Do you think we need to have a record request, or that's the extent to which you know that the Native American tribes have concerns about?
I think for the state components of the project, I think those are the major issues that we've been in discussions with, and I think through our kind of ongoing dialogue with them, I think we have a good process set up and in place, and a means for us to kind of continue to share information as we get it, to solicit input from them as the project progresses. So I think that fairly characterizes things from my perspective.
May I just ask a quick clarification on one of your responses? You mentioned, Mr. Rodstrom, that there was a paleo survey that the tribes were interested in monitoring, or how it was being conducted. Could you just describe exactly what you mean, particularly where it's in the marine environment?
So, and I may ask my colleague Holly to also chime in, but as part of our offshore geotechnical and geophysical survey, that information does provide some indication of areas of potential sensitivity, or areas of, for instance, an ancient riverbed in Nantucket Sound, or things of that nature. And those are areas that are flagged as being important in our siting of the undersea cable. And so I think those are the locations, and those are the locations we've been discussing with Native American tribes about how the siting and the installation methods for the cable can be done in a way that minimizes any impact to those locations.
That's interesting that those might have been riverbed areas. Is that perchance an indication of sea level rise progressing over the centuries or millennia?
Yes, and that I think is part of the science of this is the doing the offshore seabed mapping does provide information that helps identify, for instance, where when Nantucket Sound was exposed, during the Ice Age, and during periods of pre-European colonization that were at that point upland with river systems flowing out of the glaciers and that type of thing. So it's a exercise to help map out what that environment looks like as it exists buried below the seafloor.
Fascinating. Thank you.
Thank you, Mr. Rodstrom. So moving on to another topic. Most recently, well, this is the most recent that I've heard about the timeline of the FEIR. In EFSB G25, the company stated that the FEIR.
I'm sorry, Wayne, I couldn't hear. In what's the number?
EFSB G25. The company states that the FEIR would be submitted to MIPA in late summer, early fall 2021. Is this timeline still intact?
So Holly, go ahead.
Sorry, Ted. I was just going to explain that we do anticipate filing the FEIR in fall 2021.
Thank you. And the siting board staff would like to see the FEIR when it's filed. Does the company have a preference for having it as an open record request or for it to file as, for example, VW11 when it comes?
I think we'd be happy to do whatever is easiest for you, whether you want it as a record request or when we have it, we will file it. I tend to think it makes it easier to find if we do it as a VW because there tend to be fewer of those, but whatever works for you, we can do it.
Thank you, Mr. Gerson. For the larger documents like an FEIR, a standalone exhibit would be our preference.
Thank you. Thank you, Mr. Gerson. On the topic of more permitting, so BOEM recently published the page for the company's construction and operation plan, and I know that's a really big filing. Is there a way to get that on the record for the EFSB case as well?
Mr. Wang, I'm afraid I'm not necessarily clear what you're asking. Are you asking them to provide a copy of the link or that on BOEM for the company's construction operation plan, or are you making a record request for a copy of the construction operation plan?
I think I want the company to provide the COP as an exhibit to this docket, be it in the form of a record request, or if it's easier to have it as a separate exhibit, that would be good as well.
Why don't we track it as a record request and therefore record request EFSB 8 would be a copy of the company's construction operation plan as filed with BOEM when it becomes available.
Mr. Khan.
The construction and operation plan is a substantial document. I don't know how many thousands of pages it is. I just wanted to make the board aware of that and ask whether a link to those files, which we would announce when the COP is available, would be satisfactory.
I believe that a link could be sufficient. However, at this point, we're only taking electronic copies of documents anyway. So certainly production, even of a sizable document, should be a fairly limited problem in terms of supplying it to the service list.
Understood. Thank you.
Thank you, Mr. Khan. Mr. Rostrom, or, sorry, go ahead.
No, just to point out that the public version of the COP, which is posted on the BOEM website, and it's going to be subject to the federal scoping hearings starting next week, is available, and I think we would be able to provide that electronically if that would be, requested.
Mr. Rodstrom, I do believe that staff has taken a look at the BOEM link. And is it your understanding that there are elements of the construction plan that are yet to be provided as part of the link because they're in development? Or is it complete?
The Vineyard Wind South COP, which encompasses this Vineyard Wind Connector 2 project, was filed and deemed complete. We are in the process, however, of updating certain. So Volume 1, which describes the project, that is complete. There are certain additional analyses that are being done in Volumes 2 and 3 that are being carried out and will be provided in September. So I think it's as it exists and is posted now. It is a complete description of the federal permit application and project as submitted to BOEM, but some of the analyses that support that are being updated.
Thank you, Mr. Rodstrom. You had brought up Vineyard Wind South, and that's something that we were interested in knowing more about. I understand that this project, the Park City Wind project, is part of phase 1 of Vineyard Wind South. And I was wondering if there's any relation between the company's Q position number QP806 and Vineyard Wind South at all.
I'll maybe defer to my colleague, Mr. Arruda, but the QP806 is related to the lease area, offshore wind lease area covered by Vineyard Wind South. That is correct. Although I should note for the record, the offshore wind lease area, which was previously known as 501, which includes the Vineyard Wind 1 project, has since been segregated, and the lease area covering Vineyard Wind Connector 2 is now renumbered as lease area 534. But it's the same geographic area. It's just because the offshore wind lease area has been separated to cover Vineyard Wind 1. It was renumbered.
Thank you. Mr. Arruda, did you have something to add?
No, I agree with Chris's comments that the QP806 is associated with the southernmost portion of what was the 501 lease area, which is now 534.
Thank you. On to another subject that has to do with the COP. This is so for citing cases, we tend not to approve work that's not going to be related to this case. To a particular docket. We noticed that for phase 2 of the Vineyard Wind project, that's still very much in the air. So is BOEM looking at that as part of this COP, and would that impact a future record of decision proceeding in that regard?
I could take a crack. BOEM is, we've submitted to BOEM a construction and operation plan covering the entirety of the Vineyard Wind South area. That includes the phase 1 or the northerly portion of what is now lease area 534, which is the Vineyard Wind Connector 2 wind turbine location. But they are evaluating the entire area to include an evaluation of a potential future phase 2 project. And we've been in discussions with BOEM on exactly the mechanics of how that would be done for approval of the entire COP for the whole lease area, and then more specific approvals for the 2 phases. And so I think we're there's and I should say this is something that's being done, I think, in other offshore wind developers as well, with having 2, multiple phases. But there would be an approval for the portion of the COP covering Vineyard Wind Connector 2 that would stand alone.
So the benefit of that would be that it would truncate future permitting for a second phase. Is that a fair reading of that statement?
Well, I would say one advantage is, as you read through the COP, for instance, and look at particularly the amount of survey data that has to go into the analysis, the amount of analysis of that information. There's just a tremendous amount of study that goes on over the course of many years of the lease area. And so one advantage is that it provides the regulatory agencies, as well as the general public and stakeholders, I think a pretty comprehensive view of the entire area that will eventually and hopefully be built out in 2 phases. But that given the amount of time it takes for that, as well as the duration for projects awards and PPAs, and then project development, I think it provides a comprehensive regulatory and permitting view of the entire lease area, which is then further refined as each phase is advanced.
It's probably worth noting that what we have in front of you folks today is very specific to essentially the middle segment of the lease area, so Vineyard Wind Connector 2. And at an appropriate time, we would potentially make another submittal for that future 3rd project.
Thank you, Mr. Barton.
Mr. Barton, I think our concern at this point is, at least in part, the material that appeared to be published so far on the BOEM website was applicable not just to Vineyard Wind 2, but also to future phases. So we are attempting to determine what would be specifically applicable to Vineyard Wind 2. That's all.
Understood.
And thank you, Mr. Barton, Ms. Sharkey. Mr. Rostrom, I think I understood from what you're saying would be that this wouldn't be preempting a future filing with BOEM, because you would necessarily have to have a more refined phase 2 submission whenever that comes into play. Is that correct?
Yes, I think it's the expectation of BOEM as well as ours, that as the phase 2 future project is advanced, that there would be additional evaluation and additional review of that. So yes.
Thank you.
Excuse me. I think it would be appropriate to take our mid-morning break at the moment. Mr. Brock, would 15 minutes be acceptable? In that case, we will
Yes.
be back at 11:35. Thank you. Why don't we go back on the record? I'd like to note that during the break, we have evaluated the information we had asked for in record request 8, which was a copy of the company's construction operation plan. We are going to refine the information that we've requested for in record request EFSB 8. And we expect that we will provide a much more detailed request as part of that revision relatively soon. And hopefully that will address both Mr. Khan's concerns regarding the magnitude of the information that might need to be provided on the record, as well as the staff's concerns about the specificity of the information that's provided being applicable to Vineyard Wind 2. So Mr. Wong, if we can resume with your questions.
Before I start, I think Mr. Hazel wanted to make a clarification about a previous subject. Mr. Hazel?
Yeah, on the topic of project updates that Mr. Barton and Mr. Rodstrom took us through, it occurred to me that one update that we didn't get a chance to talk about this morning was the grid interconnect line between the company's substation and Eversource's West Barnstable substation. Information request EFSB-LU-27 indicated that the Vineyard Wind may enter into a commercial agreement with Eversource, whereby Eversource would take over responsibility for the grid interconnect line. Is that correct?
That is correct.
And we sort of asked Eversource a similar question, and Eversource replied that a commercial agreement might be finalized by July 31st, and the company Vineyard Wind didn't provide an estimate for the same agreement. So I was just wondering if the witnesses could provide a sort of a general update on the status of the grid interconnect, understanding that Vineyard Wind would formally update the board when an agreement is actually reached.
I can speak from the Vineyard Wind side and say that discussions are definitely ongoing. They're generally progressing in a positive manner. I don't have an exact time frame as to when those commercial discussions will be complete, though, at this time, but they are ongoing.
Okay. And I guess, did you have something, Mr. Brock?
Yeah.
Okay. Just remind the witnesses that that's an important topic for staff to evaluate, and I understand you can't make an agreement happen before it does, but just a reminder to update the board as soon as possible when there is new information available, and that information can be updated as a supplemental filing to LU-27. So anyways, carry on, Mr. Wong.
Mr. Wong, if I could, just to the point about the COP and information in there, if I could clarify one point that I may not have answered completely clearly. I would just preface it by saying that the Vineyard Wind South COP is a complicated and large document, and I've been working on it for almost 3 years, and it's still a daunting task just to understand all the elements. But I did want to clarify that the phase 1 project in the COP, which covers the Vineyard Wind Connector 2 state permitting, is complete and sufficient from BOEM's perspective, and will be providing additional analysis, as I mentioned. But that the phase 2 of the COP is as thorough and complete as we can make it at this point, understanding that covers a future yet undetermined project, and that project, when it comes into being through, for instance, an award by a state and a power purchase agreement, and that clarity would necessitate additional analysis at the federal level of those elements in the phase 2 COP. So there would be further filings by Vineyard Wind describing that future project as those details become known. And of course, that phase 2, if it were to interconnect into Massachusetts, would be subject to all the state and local filings, including an EFSB petition and NEPA filing and so on. So I just wanted to clarify that although the Vineyard Wind South COP does cover phase 1 and phase 2, the phase 2 components will be further evaluated as that future project comes into being.
Thank you for the clarification, Mr. Rodstrom. I expect that we would mostly be looking at the phase 1 information, although I would like to note that I did have a really quick glance at the first few pages of the COP, and I know the COP probably isn't committing the company to landing in Barnstable, but it did look like the company had that suggestion in there, and you're saying that might not be the case, pending more design study and such.
Are you referring to phase 2?
Phase 2, yes.
Yeah. Phase 2 contemplates a landfall in Barnstable. And as Mr. Arruda alluded, the QP806 is an interconnection request related to the Vineyard Wind South COP area, or now lease area 534. But a final project would kind of come into being with a most likely through an award through a competitive solicitation by a state and utilities, similar to the Vineyard Wind Connector 2 project. And so since we do not have yet a power purchase agreement and have not been awarded a future project, at this point, that's still kind of a conceptual future framework, but it's not yet a kind of a specific realized project.
Thank you. So moving on from that topic, the company has described the project, specifically the wind turbine area, as having a favorable wind regime. Could one of the witnesses explain what exactly that means?
Well, in kind of simple terms, it means good strong winds, and they blow most of the time, and in particular, a couple of things we've highlighted in some of our earlier submittals is that we expect the project to be able to achieve on an annual average basis a capacity factor of 50%. We expect that we will have at least some power coming from the facility for, I believe the number was 95% of the hours in a year. And we've also highlighted that during the winter months, the winds are typically stronger than the annual average. Hence, we would expect to see a higher capacity factor, which underlies our contention that there are benefits to this in terms of the whole system during the winter. If you can produce more power using wind, a renewable resource, it means you don't have to rely on natural gas for as much electric power, and hence that natural gas can be available for heating, space heating purposes, which is something that the region struggles with. So in very broad terms, that's what we're talking about. But basically, it is a good, strong wind resource.
And you mentioned more consistent than I would assume onshore wind resources. Is that correct?
That's definitely correct. And if you look at the National Renewable Energy Labs has a nice map set that they've published for years of wind resources for the whole country. But if you look specifically at the eastern seaboard, you can see a marked advantage to the wind regime offshore as opposed to inland portions of New England.
Thank you, Mr. Barton. I had a couple of questions to follow up, but I think I'll start with because there's a marked difference between the onshore and offshore wind characteristics. Is there a difference in the design of turbines for the project for offshore? Because I think for onshore turbines, at least, if winds are too strong, the turbines have to go into rest or have to be oriented such that they're not taking on the wind. Is there a difference in the design for offshore?
Well, let me start this, and Jack or Chris may want to add to it. So I think the first big difference between offshore wind turbines and land-based turbines in at least in this part of the world is that the individual offshore wind turbines can be much larger than an onshore turbine, meaning the nacelle height is higher, the rotor diameter is bigger. So there are turbines now being looked at in the 12 to 15 megawatt range, whereas many of the onshore wind turbines, not that there are that many of them that you see in New England, are in the 1 to 3 megawatt range. There are larger land turbines being used in Texas and in some of the plain states, but they are not anywhere near the size of the offshore turbines. And of course, the higher you can get the nacelle, the wind speeds increase with distance off the ground. So that's another advantage. And the reason you can do all that at sea is because you can float the equipment in place as opposed to having to deliver it by truck. So that's sort of the fundamental difference. And then any wind turbine has a maximum wind speed at which you have to feather the blades to make sure that the equipment is not damaged in extreme winds, like in a hurricane, for example. So that applies across the board. I can't quote you the exact numbers for land versus sea, but that's a design feature of any of the turbines. Jack or Chris, you want to add to that?
I think you captured it well. As Pat said, all turbines have a limitation. So offshore has the same limitations that you would have with an onshore turbine. It just may be a higher limitation than you would see onshore. But it is a lot to do with constructability also as to why you can build such larger turbines offshore.
Thank you. So far, in the company's understanding, has BOEM had experience permitting these larger turbines, or I mean, I think that the gist of this question is, do does the fact that as technology gets better and the turbines get larger, would that present some form of impediment to BOEM making a timely finding on offshore wind projects?
I could speak to that a little. I think the within the BOEM review, for instance, in Vineyard Wind South, we present a range of wind turbine sizes, even looking out into the future up to a 19 megawatt turbine, I believe. But one of the requirements of the federal process is that you have an independent technical verification of not only the equipment, which has to be certified and attested to for its ability to be installed and perform in the way that it's designed and to last over the period of time for the project life, but also for the construction and operation. So this certified verification agent is a third party firm that we're required to hire that completes a complete separate technical evaluation of all aspects of the project, and is kind of a rigorous arm's length evaluation from Vineyard Wind's position or even the manufacturers, and that helps provide certainty. And I would say that same process and procedure, which is in place in European wind farms, have I think proven themselves in that the wind farms that have been installed for decades and operated successfully, generally try to adopt the most advanced and efficient and productive wind farm technology, and those have endured with relatively few issues.
Thank you. One more thing with regard to that, Mr. Rodstrom, you brought up the maintenance and operation. To me, when you see onshore wind turbines, they're already these huge structures, and it sounds like the offshore ones are even larger. Like, how does that come into play with regard to the amount of personnel needed, the amount of traffic from staging areas that need to come about during operation and maintenance? How does that affect? Do larger and larger wind turbines require more rigorous operation and maintenance during their lifetimes?
I don't know if Jack or Ted might know, but I'd say larger and larger wind farms do require a suitably scaled operations and maintenance program, and that having the sufficient port capacity or personnel and the maintenance schedule to maintain larger numbers of turbines is something that's kind of integral to the planning of the wind projects. I don't know if larger turbines per se require any proportionally greater amount of operation and maintenance work, but
just if I might to add to Chris's point, to some extent, and you can actually see this in the way the Vineyard Wind projects are unfolding, the availability of larger units means that you can achieve the same power output, in this case 800 megawatts, using fewer but larger wind turbines. So to that extent, there are actually fewer particular installations to maintain. The basic components, the generator, the blades, etc., are the same whether you're talking about an 8 megawatt or 12 megawatt or 15 megawatt turbine, albeit bigger. So in and of itself, that doesn't mean they require any more or any extra maintenance. But that said, this equipment is very rigorously monitored and maintained in order to keep the reliability factor where it should be. So a lot of thought goes into that. It is evolving, although in the United States we have the advantage of being able to follow what's being done in Europe, where this technology has been in utility scale for 2 decades now. So certainly the major equipment providers are able to learn from that experience, and increasingly it's actually a global market. So there are wind turbines going in Taiwan and other countries. So all of that experience can be factored into the O&M plans.
Can I just follow up, Mr. Wong, just briefly? So with regard to the larger size turbines that the company is contemplating for this project, is there any additional risk that might be associated with the greater heights in terms of lightning risks or other natural hazards that exist in the marine environment that is qualitatively different from what's been assessed previously with smaller size turbines?
But one area that we are required to evaluate with the larger turbines, and as they increase in height, is aviation risk assessment. And so, as part of the federal permitting, we're required, and we do complete risk assessments of the maximum size turbines that are proposed, and the BOEM process does allow for an envelope of a range of potential turbines, and we're required to model and assess the relative risks or impacts or factors that are involved with that full range. So I think the one area is that I know of is aviation, which is carefully studied and has to be signed off on by federal agencies.
And another question is, with the increasing heights of the turbines, can you give an estimate in terms of what type of annual capacity factor you might be looking at for this generation of turbines in this project?
So we've if you remember back to Vineyard Wind Connector 1, we were talking about a 45% capacity factor, and that was for turbines in the 8.5 megawatt range. And as we've moved into Vineyard Wind 2 and have started to look at larger turbines, that number has been upped to 50%, which is at least in part a function of the larger, more efficient machines.
Thank you.
Thank you, Mr. Barr and Mr. Green. While we're on that subject of the capacity factor, Mr. Barton, you had mentioned this a little earlier in your testimony. So 50% for annual capacity factor, that's an average, right? Right?
Correct.
And you had talked about how in the wintertime there's more, the factor's higher. Is this a simple enough calculation that you can average out, like you have higher wintertime capacity factors and lower ones for the rest of the year, and then they sort of average to 50? Is that a fair way to put it, or is it more complicated than that?
No, it's basically that simple. It's an hour by hour average, but in a sense, If and I'm not quoting these numbers exactly, but if in the summer, say for 3 summer months, you had an average capacity factor of 40%, and for 3 winter months you had 60% and 50% in the shoulder months, that ends up averaging out to be 50% for the year.
I asked this, and we'll get into this more in later topics about magnetic fields, but specifically, we've asked the company to run magnetic field models on 50%. Do you think it would be more appropriate to have different values for wintertime and for summertime, or is the difference small enough that 50% is a good value to use for modeling?
I think for that purpose, especially given that we originally started the modeling using 100%, so we used the maximum case, and then we used 50% as an appropriate annual average. I think those 2 sets of calculations accurately bracket things. So I personally don't think it's necessary to get into sort of further gradations for that purpose anyway.
Thank you. I think we'll go back and talk about that a little bit more, but thank you for your clarification on that. Okay, so we're gonna move on to a little bit more about the project need as advertised. Quick check, Ms. Sharkey, our lunch break's at 1, right?
Unless you want to take it earlier.
No, it's fine. In the company's analysis, volume 1, from 3-6 onwards, the company describes generally the generator lead line versus shared transmission option. And we're going to talk about that right now. The company states, and feel free to tell me if you need more time to get to the page. I think I'm going to just read out what the company said, and if you can't find it, let me know if that's. But I don't think you need to have it in front of you to answer the question of what I'm saying. So the company states that due to significant challenges with shared transmission, the offshore wind industry and governmental support for the industry have been moving forward uniformly with generator lead lines and direct interconnections, quote unquote, as opposed to shared transmission. Could the witnesses tell me if this statement is still true to your understanding?
I think for Massachusetts in particular, yes, that is, and as we related in the text of the petition, a year and a half back, DOER was asked basically to look at this particular question and basically advise D.P.U. and others as to whether there was merit to doing a separate procurement for shared transmission, with the idea that subsequent power purchase agreements could potentially take advantage of a shared transmission option if it had been studied and formed to a point where somebody could actually make use of it. And their recommendation at that point was they didn't feel that was necessary at that point in time, and they had a number of reasons. But to my memory, the principal ones were that the first couple of projects which use a generator lead approach were progressing fine. There were other opportunities along the Massachusetts and southern New England coast to use the generator lead approach for future projects, and that ISO had done a study that basically said you could connect on the order of 6,000 megawatts along the southern New England coast using the generator lead approach without getting into substantial upgrades of the land system. So that basically, extended to projects like Vineyard Wind 1, Vineyard Wind 2, Mayflower, some others that are sort of in the active queue right now. And as I recall the report, they did say that at some point in the future, if enough projects were developed and the most usable interconnection points along the coast began to be filled and taken, that there could be a point in the future where the shared transmission warranted another look. But for now, they felt it was more appropriate and more advantageous for Massachusetts to move ahead with the procurements that are planned and not to take a substantial time out to allow shared transmission to develop.
Thank you. And
I was just going to add briefly to Mr. Barton's statement, if that's all right. Just that the 2019 DOER study that Mr. Barton was referring to really came on the heels of a study by Mass CEC, which essentially was expressing concerns about separating transmission from generation, largely focused on risks associated with which of those should come first. And I'm just quoting here from page 3-8 from that CEC, from our analysis, but quoting from the CEC study, the generating system has no value if it cannot deliver its power to market. And similarly, the transmission system has no value if there is no power to deliver. So CEC was early on identifying the challenges and the risks associating with compartmentalizing transmission from generation for these types of projects. And that has been carried forward.
I'm sorry, and that is what?
And that has carried forward, those concerns thus far.
I'm sorry, I still didn't hear. Could you repeat, please? And that has moved forward?
Those concerns have been carried forward thus far.
Thank you.
thank you both. I have a couple follow-ups on that. Maybe I'll go back to Mr. Barton's testimony first. So Ms. Johnston confirmed that the report you're referring to is the 2019 DOER report. Is that correct?
Correct. I may have said a year or so ago, but time flies. So I was talking about the 2019 study. Yes.
That's good. And in the same section, the company describes a technical conference tabled by DOER in March of last year, which seems a long time ago, to assess the solicitation for independent transmission to occur. I think, Mr. Barton, you summarized some findings, but I believe those were, for example, you said it wasn't feasible at the time to have independent transmission structures. Those findings were from the report, am I right?
Well, I guess what I attempted to summarize was probably a mix of what was in the DOER report, some of the feedback they got at that technical conference. There certainly, it's fair to say there's a range of opinions on this subject. So, for example, at the technical conference, firms like Ambaric, who are in the shared transmission development business, were of the opinion that that it was something that could be looked at now. On the other hand, there was a fair amount of input from wind developers and others that the current system was working fine, and hence there was no need to take a big pause to explore shared transmission in more detail.
And in that same, I think this would have been bundled together with the conference. The company stated that at least in some point of time, the DOER offshore wind procurement schedule was supposed to have a transmission solicitation process independent of generation in mid-2020 through late 2021. And obviously that didn't happen, but does anyone on the panel have an update with regard to that procurement process?
So my understanding is that was really the question that led to this examination of should there be a separate procurement for shared transmission. And what ended up being the outcome of the report, the conference, and the discussions was that basically that procurement would be deferred until sometime in the future. But I don't believe a specific date was set for that. But the alternative then was to move ahead with procurements for more power purchase agreements with the assumption that at least the next round would be based on generator lead projects.
Thank you. And you had, Mr. Hazel, you have something to ask about use of the word substantial. Could you expand on that?
Yeah, I think Mr. Barton was quoting from an ISO New England study that a certain amount of offshore wind could interconnect under the generator lead line process without substantial upgrades to the land-based transmission system. I guess you don't work for ISO, but do you have any idea where they're drawing the line about what a substantial transmission upgrade is? Because it kind of sounds like the interconnection upgrades for some of the early projects are getting quite large.
So my remembrance of this, and I admit I have not studied it carefully or recently, was when they were talking about quote substantial, they were referring to essentially large scale additional lines to the 345 kV backbone system once you moved away from the coast. I don't know I'm sure they did put a number to it, but I don't recall what it is. And Jack, I don't know if you can elaborate on that at all.
I can't speak specifically to that, but I guess one of the points I'd make is whether it's shared transmission or not, the onshore portion can only handle so much before the upgrades need to occur. So whether it's a gen lead or whether it's shared transmission, I don't think that changes what needs to be done onshore. And so I guess that's just the point I would make there. The 6,000 megawatts before significant, grid improvements would be needed. That would be relevant whether it's a direct generator interconnect or shared transmission, because at the end of the day, they're all landing onshore.
Yeah.
Fair enough. Thank you for the explanation.
Thank you. Ms. Johnston, this question is more general, so I'm directing this at the whole panel. Mr. Barton, you had explained that at least in Massachusetts, the state seems to be heading towards shelving a shared transmission network for now. Shelving a shared transmission network for now. And on page 3-7 of the petition, the company actually states that ISO New England limits connections from a single source of offshore wind, I guess, to 1,200 megawatts. Is this prohibitive to having more shared transmission? And in your understanding, is this cap for a single generator or is it for a single transmission line?
So there were a lot of questions rolled into that one, but my understanding of the 1,200 megawatts is, as it says here, that's ISO New England's normal design contingency. So the loss of one element of the system does not result in the loss of any more than 1,200 megawatts of capacity. Some of the shared transmission systems that I've seen being discussed are larger than that, but they may very well consist of more than one set of cables and more than one. Many of them are based on HVDC technology. So that would certainly inform how big you allowed any one element of the system to get. Not to say that you couldn't design a 2,000 megawatt shared transmission system, but it could not be reliant under these rules on a single cable, for example.
Thank you, Mr. Barton. Mr. Green, did you have a follow-up?
Yeah, on the question of an offshore grid or shared network, as I think the term was used, versus a generator lead line type approach that Vineyard Wind is now proposing. I'm wondering if the choice really is all that binary or mutually exclusive. In other words, if the industry, the offshore wind industry, gets started with generator lead line type connections, but someday the virtues of a grid become more evident, is there a transition opportunity for interconnections from wind farms to specific substations to become part of an offshore grid at some point in the future?
So I'm thinking that for a project like like Vineyard Wind Connector 2, once the project is built, and assuming it's built using basically an 800 megawatt generator lead connection into West Barnstable using 2 AC circuits, which is a good, solid, stable connection into the system. Once you've spent the money to do that, I'm not in my head conceiving of a situation where an owner would then say, yes, I'd like to spend a whole lot more money to buy a piece of a shared transmission system. So I think that shared transmission is then something that's used by future projects that may just sort of be on the drawing boards at this point.
I guess what I'm thinking in my question about whether there's the potential to transition into a grid is sort of looking back at the history of the generation industry, which I think, in the time of Edison started out as a generation facility connecting to a particular substation with distribution to a defined area. And over the decades, that did grow into a grid that we now have today, but it didn't start off as a grid type of, at least at the transmission level, approach. So is that analogy of how the onshore generation substation connections evolved relevant to the offshore industry?
So I guess I well, neither of us were around at the time of Edison, but I think of this as more the analogy of we have in New England a well-developed grid that's evolved over many decades. A number of the conventional generation facilities have closed or been retired, and specifically in southeastern Mass, Brayton Point and Pilgrim come immediately to mind. So in one sense, what the offshore wind generation is doing is taking the place of those retired resources. So when Pilgrim retired, something close to 700 megawatts came off the southeastern Mass grid. Vineyard Wind 1 will put 800 megawatts back into that general location, and so on. So I think of it more as you already have a fully evolved grid, but you're changing the mix and location of the generators, at least for the first several projects.
And last point to ask about is, do you see any likelihood of interconnections between different wind farm installations, again, to provide more pathways to the onshore grid, perhaps sometime in the future? Would that networking of the point-to-point connections provide some benefits in terms of added reliability or increased capacity deliverability?
I could just, I mean, one place to look, I think, about the future of offshore wind and the regional or even national grid infrastructure is Europe. And, Europe has particularly countries like, Germany and the UK, which are, among others, have, enormous installations. There are projects involved to connect, country to country, to be able to move power as the wind regimes fluctuate, and to be efficient and in a broader distribution of electric power, not only within countries or within regions in countries, but between countries themselves. And there are, I know, or I believe there are at least 2 plans for offshore wind energy islands to be constructed that would provide kind of central nodal terrestrial places between countries in the ocean that would provide greater interconnectivity. Whether or not that's a blueprint for the United States, or if there'd be, or exactly how it relates to the shared transmission questions that we've been discussing, I'm not entirely sure, but I think it's an interesting thing to look at a much more mature, much larger offshore wind industry that is largely been generator lead line, and that is now looking at the interconnections and efficient build out of even further energy in Europe. But I think it is notable that they're getting to that point now only after a couple of decades and many projects later of projects built the way that they're being done currently in the U.S.
Seems like the analogy of that type of.
I'm sorry, Eddie, could you start over again, please?
Sure. See if you can hear me.
Yes.
It seems that if the Europeans are looking at country to country networks or offshore grid connections, that's probably a concept that's relevant here in terms of the entire East Coast, or a region rather than just within one state or neighboring states. Would you agree with that?
I think so, especially given the level of wind. I think the UK had 50% of its power generated by wind at one point this year, and I would imagine it's no small feat to build an entirely new island in the Baltic Sea to provide an efficient interconnection point for transmission between nations. But they certainly are they have a long lead on us, and are thinking through this. And I think it's probably an area where we could learn from them.
Back to you, Mr. Wong.
I believe Mr. Ruda had something to say, or.
I was just going to add to Mr. Rodstrom's comments. I mean, it's not inconceivable at all that you could have interstate interconnections in the future. it's not just, it's kind of a combination of multiple things here. You've got the technical side to solve, as Mr. Barton mentioned about the single source loss of 1,200 megawatts. So there's the technical side, but you also have the commercial side and the tariff side that would all need to be intermingled here and worked out just based on how the different regions tariffs are written, their ISOs are managed. So there's a lot of moving parts to, you know, having that broad network going across different control areas. It's not inconceivable to happen, but there needs to, it's not just a technical issue. There's also the commercial, the risk, and then there's the tariff language that needs to be able to deliver your energy to markets in a way that removes risk from the ownership. So that's all. I mean, that's all I was trying to get across. Is it's not just strictly a technical issue.
And just to add to Mr. Aruta's statement, while shared transmission is certainly conceivable in the future, for this project in the here and now, the generator lead line approach is really the only strategy viable for Vineyard Wind Connector 2 on the timeline required. We also, of course, have the benefit in this particular project of having, with the orientation of the lease area and the landfall site and interconnection point, essentially having a route that heads due north and is close to the shortest possible route. So thereby minimizing cable length and associated impacts.
Ms. Johnston, just to confirm for us, the company is still intending to start construction around 2023 and 2024. Is that correct?
I would actually look to Mr. Rodstrom to just confirm the construction schedule if possible.
Yes, that's correct. Particularly given the current state of the federal permitting, we think that's and the milestones that have been issued through BOEM and the federal permitting dashboard, we think that's accurate.
Thank you. Mr. Green sort of also talked about whether, and this question is a little bit teed off of that. Mr. Green talked about how this project could evolve in the future to become part of a shared network. I have a question about if for some reason the scenario that Mr. Aruda was alluding to, where all the permitting functions somehow align and federally or statewide, the company is required somehow to move towards a non-generator lead line connection, would the project team be able to address such a requirement? This is really hypothetical, but if you could indulge that question.
At this, I'll just speak on behalf of the physical interconnection here. At this particular time, Vineyard Wind 2 has a valid study, system impact study, a very valid, good interconnection point with a gen lead line. There would be no benefit to Vineyard Wind 2 to changing that right now. That's all been studied and approved. And the gen lead line for this particular project is absolutely would be the most efficient way forward for this project.
Thanks, Mr. Aruda. Does anyone else have anything to add? Okay. Finally, this is, so in that section we've been talking about the generator lead line versus shared transmission. The company also finally lands on a statement that the Vineyard Wind and Vineyard 2 projects together sort of are similar to a shared transmission anyway, because they share the same offshore route, and then they come on to the shore at similar points. They would come on to shore at similar points. Yet in a footnote on page 2-1, the company states that it still envisions the projects requiring 4 circuits instead of maybe being able to have 2. I understand that maybe previously, with the way Vineyard Wind 1 was supposed to have progress in the company's initial planning, it wouldn't have been possible. But at this stage, the fact that both projects are undergoing permitting and have relatively well defined the design parameters, is that an option to have them share that transmission line, or is that still, in the company's view, not feasible?
I think the key here in terms of Vineyard Wind Connector 1 and Vineyard Wind Connector 2 quasi-operating as shared transmission, I think the key point is that the cables will essentially be operating at capacity, where neither project is building enough capacity and transmission to accommodate an entirely separate project that would simply plug in, for example.
And I would add to that, you know, basically, assuming Vineyard Wind 1 and 2 are both built as currently proposed, you would end up with 4 400 megawatt AC cables in a narrow shared corridor, basically. And if you were to say, what would it take to reduce that to 2 cables, for example, that would essentially mean, using current technology, you'd have to go to an HVDC system, which would add a huge element of cost to the project for, in my opinion, given the distances involved, no real advantage. So I think what we have on the table is the solution that best balances cost and environmental impact while providing a very reliable solution.
And I might just add that the switch to DC would not only have cost implications, but also some substantial considerations on the environmental side of things, since it would require large converter stations at both ends.
I'm sorry, since it would require large what?
Large converter stations at both ends of the transmission system.
Thank you for the clarification on the HVDC versus AC. I hadn't realized that. So because the company states that for shared transmission, the idea of shared transmission have mostly been focused on HVDC. Is the reason for that because it requires so much more megawatts being connected?
I don't want to speak for firms that are in the shared transmission business, but my understanding is that typically they have gone with an HVDC approach, one, as a function of the distances that they're trying to cover, and 2, the larger capacity of a given set of cables. But it's oftentimes driven by the distance. If you're trying to connect to New York City, or you're trying to connect to Boston from lease areas off southern Massachusetts, you basically have exceeded the feasible length of an AC line.
Thank you, Mr. Barton. Ms. Johnston, to clarify, you had said that both projects would be at capacity. Were you referring to the fact that both would be 50% annually averaged and they would add up to 100%?
I was referring to the fact that if you have, so approximately 800 megawatts for both projects, for either project in isolation, up to about 800 megawatts, 2 offshore export cables of the types we've been discussing are required for each of those projects.
I'm sorry, I'm missing the occasional word from you. So
Do I
approximately.
have significant background noise?
No, occasionally a word drops out. So let me read what I have. So approximately 800 megawatts for both projects, for either project in isolation up to 800 megawatts and then.
Okay, why don't I'll start over and I'll speak a little bit closer to my mic and hopefully that solves the problem. I was just trying to explain that my statement earlier in terms of cable capacity regarding Vineyard Wind Connector 1 and Vineyard Wind Connector 2, both projects are of approximately 800 megawatts, which when you're discussing the cable types that we're discussing now, each of those projects requires 2 circuits to get that transmission to shore. So if they are operating at full capacity, then those cables are essentially at full capacity. And Mr. Ruda, you may have more detail to add, but that's what I was trying to explain earlier.
Thank you.
No, that's correct. There's no headroom built into the cables to speak of to accommodate another project.
And presumably both cables would be operating with similar profiles at the same time. So if you had a very windy day, most likely both projects would be producing near the full capacity. Is that right?
That's correct.
Is it general practice in the offshore wind industry to not have some safety factor? I mean, I think I understand that most of the time. Sorry, recycling is coming through. Is it your understanding that most of the time, because wind generators don't operate at their full capacity, that it's okay to just have the redundancy instead of having extra headroom on the lines? Am I understanding correct?
You normally would not overbuild the actual AC transmission cables because there's other elements that are involved and it impacts equipment on either end. So in this particular case, it's not so much the redundancy that's built in, though it can be looked at that way in some way. You have 2 separate 400 megawatt circuits here that, basically electrically operate independently, though there are some tie breakers in the single line diagram that could be closed to tie them together if you had an outage situation. But normally you have 2 400 megawatt circuits. Those cables are sized to handle the full 400 megawatts coming ashore and connecting at the point of interconnect.
Thank you.
Can I ask Mr. Arruda a follow-up question? Can you elaborate a little bit about how the cables are able to operate independently? Like, can they be switched independently, or are they really more operating as a single high capacity cable in 2 separate bundles or something like that?
They're electrically separated. They're electrically separated into 2 400 megawatt cable systems, and the offshore platform and the onshore will have tie breakers that you could tie them together. If you had to do maintenance, say you had to take a cable out of service for one reason or another, you could close a tie breaker. Those studies need to happen in the future with ISO New England, but there is that optionality so that because it is an intermittent resource, and as Mr. Barton's explained, the capacity factor using round numbers at 50%, there are times where you may have an outage situation on one section or one of the 400 megawatt circuits, but you could close a tiebreaker to at least take advantage of that full 400 megawatt circuit. Say you only had 200 megawatts generating from each group of wind turbines. So you might as well use the full 400 megawatts you have available to you. But that would be an off normal situation. Normally tiebreakers are open, 2 separate 400 megawatt circuits coming ashore, and those cables are sized for those full 400 megawatts.
Okay, so help me understand, does one cable, this might be a simplified explanation, but does one cable, say, serve half of the wind farm and the second cable serves the second half of the wind farm? Or is it the case that sort of like, to the extent that there's capacity on the line, all of the wind turbines could be routed through one or the other, depending on how strongly the wind is blowing?
No, it was the former that you said. Each cable is dedicated to one 400 megawatt group of turbines coming ashore.
Gotcha. Okay. Okay. Thank you. That helps me understand electrically how it's set up.
Sorry, this is a callback to Ms. Johnston's earlier testimony about the Mass CEC and DOER endorsing the generator lead line transmission option. These were all done before. I guess Vineyard Wind 2 was on the horizon at that point. This was done in 2019, and you said Mass CEC was before that. And my understanding was that, from reading the text, could be wrong, was that these were explicit endorsements of the Vineyard Wind 1 approach. Do you have any confirmation or any statement that you can rely on that says that for Vineyard Wind 2, this is a good approach as well?
So I don't believe either study was directly targeted at Vineyard Wind Connector 1, unless I'm mistaken, Mr. Barton.
I
believe they were just independent studies.
The only thing I was going to add to that was that by time the technical conference that we talked about earlier occurred, which was an opportunity for people on all sides of the debate to weigh in and make their opinions known. By that time, not only had Vineyard Wind 1 been in permitting for a good 3 years, Vineyard Wind 2 was fully formed. The Park City Wind Award had been made. Similarly, the second round Massachusetts procurement had gone to Mayflower, and Mayflower was advancing their plans, which are also based on a generator lead. So those 3 substantial projects at a minimum off the Massachusetts coast were out there in full public view when that debate was ongoing.
Thank you for the clarification. Ms. Sharkey, I have a standalone question about BOEM, and the other questions are more related to, like, they're all related. Do you think we should take the standalone question now and then go for break, or should we go for break right now?
We could take our break now and then come back to that after lunch, if that works better for you.
How does it work for Mr. Brock? Do you want to take a break now?
I'm fine with whatever you want to do.
Okay, so I'll start the question then, since decision's mine. So in the company's analysis to the petition, it provides a very extensive process behind BOEM's lease area sale. So to help fill out the record a little more, is the company able to provide for the record the stated aim for BOEM's competitive lease sale? I think it's all implicit, but I don't have a direct statement that can say this is what the sale intended to do. I was looking at the pages 1-7 to 1-8 in the analysis. I don't know that has anything that's directly saying these are the stated aims of our competitive sale.
So this particular section of the petition was really trying to provide some historical context to how all of this came about, and as it relates here, BOEM started the process of looking at potential lease areas off Rhode Island and Massachusetts back, I believe, in 2009. So this has been underway for a long time. And it recounts how the initial auction was held, and both the Vineyard Wind lease 501 and the adjoining Bay State lease were spoken for at that point. And then there was there was a subsequent auction held for the 3 remaining lease areas to the east, and that was in, well, it was at least 3 years ago, if I remember correctly, 2 years ago. But anyway, that was for the 3 lease areas to the east, one of which Vineyard Wind bought, lease area 522, one of which went to Equinor, and one of which went to the Mayflower project. So that was the culmination of the leasing activity for the Rhode Island, Massachusetts wind energy area. And projects are in development to varying degrees in most of those lease areas at this point. So I'm not sure if that answered your question or not, but that we were basically trying to give a little history or background on how all this came about.
Thank you, Mr. Barton. Not exactly. I'll rephrase a little bit. I don't believe Bowen would go through this process for no reason, but does the company have, can you describe, or do you have a document that states Bowen's objectives for leasing out these areas? It'll help to fill out, for example, what the company is obligated to do under this federal lease program. It's not just to buy land, to have options for land offshore. What's the stated objective for this whole exercise is what I'm looking for.
Okay, so I off the top of my head, I can't point you to a specific BOEM document that explains that, although I'm sure one exists. But fundamentally, their charter, starting back in the 2009-2010 timeframe, was to work with interested states that had good wind resources, so the southern New England states being among them. Their charter at that point was to begin a process that would enable a U.S. offshore wind industry to develop. And that process had to start with making lease areas available to would-be wind energy developers, with the assumption that once folks made the commitment to spend what has become a very substantial sum of money on a lease, that they would then move forward with the development of projects. But the states obviously have something to say about that, because the opportunities are paced to some extent by the state's progress in making available power and competing power purchase agreements. So, Massachusetts has finished 2 rounds of that and has a 3rd in planning. Connecticut has finished a couple rounds. Rhode Island has finished a couple rounds, and so on. So I think all of that has been aimed at supporting BOEM's objective of standing up a U.S. offshore wind industry. And of course, in the first couple months of the Biden administration, that's been underscored by President Biden announcing the 30,000 megawatt goal by 2030 for offshore wind in U.S. waters, which effectively means primarily the eastern seaboard, and in particular, New England, New York, New Jersey, Maryland. So.
Thank you, Mr. Brown. That was really helpful. And to the extent that a winner of a particular lease area, are there any federal obligations for how to realize these wind resources, or is it really just up to whether, obviously the company's put in a lot of investment in this area, but if somehow stuff falls through, is the company still liable to make up this wind area? Or if finances don't work, it's just fine.
Maybe I can put a little finer point on that question, which is once the company, let's say, wins an auction and possesses the leased area, what is its obligation in terms of when it has to proceed with the project, or can it perhaps just hang on to a lease as a sort of speculative hold without actually producing a functioning project?
So if I heard the question right, I think you coupled both the lease and the power purchase agreement. So once a company wins a power purchase agreement and then proceeds on to the point of having approved contracts with the purchasing utilities, they have entered into a binding agreement at that point to make good on developing the project. And I mean, there are certainly some outs and exemptions for things that nobody could perhaps foresee. But at that point, you have a contract with the state to deliver 800 megawatts by a certain date. And I think everybody involved takes that very seriously.
And on the BOEM side of the equation, do they have a particular time frame that's allowed for the company to demonstrate milestones towards commercial operation, or do they give you the entire duration of the lease agreement to basically, decide what is the company's commercial approach? Is there a performance milestone from BOEM that requires some demonstration of progress at a certain point prior to the end of the lease?
Especially in the lease document itself, are there obligations and milestones that are contained in the lease document provided that the company signed on to when it accepted the lease?
We should, rather than give a partial answer to that, we should probably do this as a record request, because there are some schedule line items in the lease, and they talk about how long you can take to, for instance, get a sampling and analysis plan in, how long you can take to do the upfront study work, et cetera. But rather than meander on that, I think it probably is a good subject for a record request.
And I guess I would just say, I'm reading the lease right now, but in general, BOEM does require the Vineyard Wind to be kind of advancing the development of a project. There's a trigger on the time frame once a project is approved and constructed, but most of the lease language relates to requirements for how approvals are done, surveys done, and so on. But I think I agree with my colleague, Mr. Barton, rather than trying to provide details on the fly here. I think that would be something we can get back to you on. But in general, BOEM's expectations are that you are actively advancing the development through things like offshore survey and other studies to progress the ultimate utilization of the lease to develop a wind farm.
That's a useful general answer, and I think we'd like to get the specifics in the record request. So why don't we proceed with that?
Okay, so basically to restate, I believe the record request are there obligations and milestones that are contained in the lease document that BOEM requires that the company signed on to when Vineyard Wind accepted the lease award. And that would be record request EFSB 9.
Thank you, Ms. Sharkey. Before we go on break, and this question might be answered in the record request, but Mr. Barton, you had grouped together the power purchase agreement and the lease sale. I wasn't sure that Mr. Green was saying that at the time, but it is. So would having a lease require the company immediately to look for a state or you know to get a power purchase agreement, or can you hold until you find a find an auction that you would like to participate in indefinitely?
So I guess my opinion on that is that this is the lease is the first step. You have to have a lease. You have to have a place to build a wind farm before you can start competing for power purchase agreements. But once the lease is in place, other people have other leases. This is basically a market-driven system. So the states each have their own ideas on how much offshore wind they ultimately want to contract for. They have their own schedules. And then the developers have an idea of what opportunities are coming. Compete if so far history has proven they compete very aggressively for those opportunities, but the key word being compete. You have to weigh in, put a good offer together, and hope you get a power purchase agreement. You can't simply sign up for it. So this is a market-based system.
I'm all set. Does anyone else have questions on this section before we go on break? Ms. Sharkey?
All right, then we will break for lunch and come back at 2:10.
So Andy, this remote format works okay, but it doesn't seem quite the same not walking across the street to the cafeteria at one financial center for lunch. So.
And that's a good thing too.
That's true. I was never able to pass on those big $1.50 chocolate chip cookies. So
I enjoyed having leftover Indian food for lunch, and I probably would have not had that had I been back at the office.
Yeah.
I hope everybody else had a good lunch. But we do miss our colleagues and applicants and interveners and everybody else that we have not seen much of lately in person.
Yeah. Well, I was thinking back. I think the last time that any of us had a chance to be together in person was the site tour, which was many months ago. So
it was.
Yeah.
September, I believe.
Mm-hmm. Mm-hmm.
Okay, Alan, back on the record. It looks like everyone has rejoined one way or another.
Okay. So I will resume questioning on the project need. Earlier this morning, we talked about the quality of the wind resources in the lease area. And so in the project need description, the company states that the valuable nature of the wind resource area makes it likely that the project would be available. Makes it likely that the Park City Wind project would be available when this particular project, Vineyard Wind Connector 2, would be realized. Could the company sort of fill that description out a little bit? How exactly is the quality of the wind resource connected to whether a project can be realized, whether a project will, in that area, likely will be realized? Sorry if that was a little rambling.
So I would say just to start, the strength of the wind resource or the quality of the wind resource is one of the foundational considerations that contributes to the commercial viability of the project. And so in the particular case we're talking about for Vineyard Wind Connector 2, the project's ability to achieve a good capacity factor was reflected in the bid the company was able to make into the Connecticut DEP procurement, which ended up being the winning bid. There obviously are many other considerations that go into that, but having a good, strong wind regime is a foundation to a successful project.
Thank you.
Can I ask a follow-up question?
Go ahead.
Mr. Barton, does this quality or the strength of the wind vary across the whole Boehm lease area off the coast of Massachusetts and Rhode Island? Like, is a Vineyard Wind's lease area, advantageous even compared to the other adjacent lease areas?
So we don't have access to the wind data that other people have collected for other lease areas. So we can't answer that with precision. I would say though, within our lease area, which is roughly 10 miles wide and 30 miles long, as you get further out to sea, the average wind speed does increase a bit. So there is that difference. I would not expect there to be big differences between, say, the Vineyard Wind lease area and our immediate neighbors to the east and our immediate neighbors to the west.
Thank you.
Thank you, Mr. Barton. In terms of commercial viability, is that for both the building of the project and also operating, or is that particularly just with regard to getting the offshore wind farm off the ground and up and running?
Well, this kind of goes back to something we talked about before lunch, of this being a market and competitive system. So it really is some of both. In order to make a competitive, and in this case, a successful bid into a state procurement, you have to have a project that can be built economically and a project that will operate economically and reliably. And all of that gets dialed into the price that the owner is willing to commit to in the state procurements. And it is very much a competitive environment.
Thank you. So, final question on that. If we're walking that idea through, you're saying that, is it correct to say that the attractiveness, the viability of the wind resource in that area meant that if the US ever were to want to start an offshore wind industry, it would have been in that area? Is that, maybe that's going a little too far?
Well, I could, Ted, if I get, I think it's accurate to say that if you look at the historic offshore wind data nationally, that the kind of historic wind regime offshore of New England is among the best in the entire US. And that, combined with the proximity to several or many major cities and electric demand centers, and the relatively shallow seafloor and outer continental shelf depths, make it a fairly ideally suited location to establish a viable offshore wind industry.
Thank you, Mr. Rostrom and Ms. Barton. Mr. Hazel, do you have anything to add? Okay, so this morning we also talked about Boehm, but we didn't specifically talk about the record of decision. So in the first case of Vineyard Wind Connector 1, the siting board relied heavily on the company's obtainment of the record of decision. Does the company still see the record of decision as a reasonable indicator of progress for this case, given given what we know about what we've known about how that was delayed a little bit. Well, from the previous administration.
Well, on your second point, I would say that our experience working with BOEM under the current administration, as well as the staff that manage the FIPC or the FAST 41 permitting process, that has been a clear kind of focus on establishing and meeting the milestones that have been set forth. And so I think we're feeling fairly confident in that the milestones that have been set for federal agencies on the federal permitting side are progressing, and that those will be met. I would also say that they are dealing with quite a number of projects as well, and they are staffing up, and they are gaining experience, and they're kind of learning from the experience of Vineyard Wind 1. And so I think in several respects, things are moving in a very positive direction. As far as a reasonable milestone for progress, I think there'll be some interim steps between now and when the record of decision is issued that could give some strong indications of how the federal permitting is progressing and the overall project schedule will be achieved. The next week are the scoping meetings for the environmental impact statement process. That there's already been a third party consultant hired to work on that. Then when that draft comes out, there'll be further indication of how things are progressing. So I don't think necessarily the record of decision will be kind of definitive. I think there'll be some good signals along the way. And I think that, the company would like to have as much flexibility in being able to move the project forward as possible at the state level, along and in parallel to the federal permitting process.
Right. Mr. Hazel?
Well, I was just going to ask, like setting board approval aside, if you could pretend you didn't need that. I mean, would the company realistically start construction on land or any portion of the project before receiving a record of decision from BOEM?
Well, I guess I would kind of note that, one of the aspects of the offshore wind project we've seen with Vineyard Wind 1, and it seems will be similar for Vineyard Wind Connector 2, is multiple time of year restrictions or further limitations on when construction can occur. Issues about supply chain or also related to time of year restrictions and endangered species measures to limit or avoid impacts. So I guess I would say that although it's best to have all federal permits in hand, that given those limitations and the tight sequence and the closely coordinated offshore and onshore construction schedules and procurement schedules that we have, that it is not unreasonable to think that some early stage construction could occur prior to the record of decision.
So even before the company receives an ultimate federal approval, Vineyard Wind would reach a level of confidence in the project that the company would start to expend significant resources. Even I guess that's a risk tolerance question, but I guess I'm just trying to understand, where along the permitting pathway does the company say, okay, this is really locked in and we can start to spend serious money on building a
I think I might defer to my colleague, Mr. Arruda, because we've had some similar thoughts on Vineyard Wind 1. But I think you've put your finger on it, that it's really a risk tolerance, and the cost benefit of expending money in advance of final federal permitting to coordinate the various aspects of the off and onshore works, and that the gains of having some early stage, particularly preparatory work or work in coordination, say with the town of Barnstable on some of the coordination there, may be worth the risk, despite the fact that the final federal permit's not been issued.
I would agree with Mr. Rodstrom. I mean, to your comment, Ms. Hazel, that's really the key component, as you said. It's risk tolerance. How confident is the project that it will get its final permits in hand? Because you cannot reach financial close without your record of decision. But as Mr. Rodstrom pointed out, there are time of year restrictions, and there are certain parts of the project that you would need to advance, while it'd be somewhat limited, but you will advance them in order to de-risk your schedule once you reach financial close because of those time of year restrictions. You also have schedule impacts where you would need to likely fund some of the transmission and grid interconnection aspects, whether it be the engineering side and procurement of some of the long lead time items, where you would then have to put some money up maybe prior to having all of your permits in hand. But it really comes down to ownership's risk tolerance and trying to meet an overall schedule objective.
And did I hear you correctly that the company's financing, or at least a part of it, some part of it, is tied to the record of decision?
I'm not a finance expert, but I would go out on a limb to say that I don't think you would reach full financial close without having all of your permits in hand, and the record of decision being one of the key, or the key permit, federal permit. You would need to have that before you're going to reach financial close.
Thank you.
If I could just follow up on that line of questioning, I'm interested in understanding what limitations BOEM applies to the company in terms of either actual construction activities or preparatory activities in advance of receiving the record of decision. Is there a sort of boundary that you can define in terms of what they allow prior to receiving the record of decision versus what is prohibited?
Well, so I don't believe any offshore construction can occur within the lease area or the lease granted by the or the easement granted by the federal government for the cable corridor until the record of decision and COP approval has been issued. So I think that is a precursor to construction.
And what about onshore activity?
I'll defer to some of my colleagues, but there are probably certain aspects of the onshore work that could occur that are strictly governed by state permitting that you could do prior to having the record of decision. But I think it would be specific. It would be, you'd have to look at each one of those specific portions of the project at which, you know, you're looking to advance ahead of having the record of decision.
So correct me if I'm wrong, but the scope of the record of decision is the entire project, isn't it? All the way from the turbines to the interconnection and substation?
That's my understanding, but I'll defer to Mr. Barton and Ms. John.
And I think that's right, and that's because underlying the record of decision is the NEPA process. So BOEM looks at the entire project as part of its NEPA review. But I think what Mr. Rodstrom said a few minutes ago is also correct, that the BOEM's jurisdiction is much more clear for the in-water parts, well, basically anything in the outer continental shelf. So I think there is more latitude to pursue some limited elements of on-land construction in advance of getting the record of decision.
Right. I get the sort of general concept of offshore versus onshore project activity being potentially permissible. And let me test out a few specific ideas or components. In advance of the record of decision, would BOEM allow, let's say, in-street construction of duct bank and placement of cable? And these may be record requests if they can't be answered right now, but I just wanted to at least explore it.
Could you just clarify the what cable are you referring to?
I'm referring to the Vineyard Wind interconnection cable. So, from the landfall area to the substation. If let's say the town of Barnstable were digging up the roads to put in some water mains or some other infrastructure project and said, hey, can you guys put that duct bank in, even though you, let's say, hadn't received the final record of decision, would BOEM allow the company to install the duct bank and cable prior to the final record of decision, just as a jurisdictional matter?
Like, as I alluded to earlier, I think there's a clear line certainly where BOEM issues the easement for the cable laid in the offshore component, but there's no similar easement granted for the onshore component, from my understanding. So to that degree, I think there is a greater latitude, as long as the activities are consistent with the rest of federal permitting, for some of those activities to occur onshore.
And with the understanding that you would have to have all of the relevant state, regional, and local approvals before you could go ahead with that. So you'd need to be done with MEPA, you'd need the EFSB decision, you'd need the Cape Cod Commission decision, you'd need a street opening permit. There's a long list of other approvals that you would need before you could proceed with that. But I think from the federal perspective, the answer is yes, you could.
I'm trying to remember the sequence of MEPA versus NEPA. Can you refresh my memory and tell me whether MEPA can issue a final certificate prior to the conclusion of the NEPA process?
Yes, and they did just that for Vineyard Wind Connector 1.
Okay. So in theory, it is possible then for state permits to be issued prior to the record of decision in the scenario you just described, Mr. Barton, that could facilitate on-land construction activity.
My understanding is that is correct. And in fact, again, harkening back to Vineyard Wind Connector 1, we had all of our state, regional, and local approvals well before the federal process concluded. Now, granted, the federal process was delayed unexpectedly, but nonetheless, we had all those other approvals in hand well before the federal process wrapped up.
Can you, for the panel, can you provide some examples, as many as you can think of for now, of aspects of the citing condition about demonstrating the likely to be available to contribute to regional energy supply standard, which has been reflected as this test of whether you've obtained the record of decision. That's how it's been implemented practically. What I'm looking for are examples of let's say, degrees of flexibility where the company would want the ability to begin either contracting or constructing aspects of the siting jurisdictional project, the siting board jurisdictional project, in advance of the record of decision that would help speed things up or facilitate the project. You know, where you might be looking for, let's say, more flexibility than what was provided in the last proceeding, or, you know, back to the time of the Cape Wind decision where this all originated.
Well, I think one of the speakers a few minutes ago touched on an obvious one, and that being the potential to begin some in-street duct bank installation if that was appropriate in order to properly coordinate things with the town of Barnstable. And another one might be because of some of the seasonal restrictions on land clearing. There might be a case where you would want to clear the substation site somewhat earlier in order not to get hung up on some of the seasonal restrictions for that. I mean, those are two right off the top of my head. There likely are others.
So is it fair to say that that type of flexibility, if granted, could produce some benefits in terms of either lower costs or perhaps even environmental advantages?
I would say yes, as a general matter, and my reasoning for that is you could envision a scenario where having to wait for the rod and then start the whole sequence could, depending on when things fell, could mean that you lost an entire year in the construction schedule. And if you lose a year in that schedule, that means you've lost for a year the CO2 reduction benefits that the project provides. You've delayed some of the other economic benefits. So it's potentially a fairly big issue.
And if I could add, I think one point that we haven't quite focused on is the fact that the transmission duct bank, for instance, is going to be constructed through Barnstable in coordination, we expect, with a sewer line installation project, and that, you know, Barnstable being a very seasonal community that relies heavily on its summer tourist season, and the limitations of construction then, along with any utility relocation schedule implications there, and traffic management, it becomes a very kind of complex scheduling issue, managing limitations and complexities on both our project and the town side. And so I think it's not only in the benefit of the Vineyard Wind to be able to have some of that flexibility and schedule, but it allows for, as we touched on, some coordination for segments of that sewer or associated utility relocation steps that are required to coordinate two fairly significant infrastructure projects closely and make it work given the limitations. We're not there yet in talking with the town, but I think we are working towards a coordination and having more flexibility rather than less, and a deadline that doesn't have to wait entirely up to the rod would allow for both us and the town and associated stakeholders to be able to find the best possible schedule that works for everyone.
And I suppose another consideration is the timing of the carbon reduction benefits of bringing another 800 megawatts of wind into the grid, 800 megawatts of capacity. into the grid. And obviously the state has goals that are measured at certain milestones. So delays are not without some consequence. Do you agree with that?
Yes, absolutely. I think the state's set some very ambitious and laudable carbon reduction goals for this decade and through 2050. I think everyone, well, I think many people agree that they're ambitious, but entirely critical for the Commonwealth's future, and accomplishing that, plus all the associated grid upgrades and all the other factors that will allow the Commonwealth to meet those goals, are going to require large-scale renewable energy like offshore wind to come online as soon as possible and continue to build towards a zero carbon future.
And I don't mean to detract from that last answer, Mr. Rodstrom, but putting aside the fact that this project is contracted to Connecticut distribution companies entirely, isn't that true?
Yes, that's correct.
So from a sort of, bean counting carbon perspective, the carbon reduction benefit of this particular slice of offshore wind is going to hit the Connecticut ledger, not the Massachusetts greenhouse gas inventory. Is that true?
I guess I think of that in terms of that from a strictly accounting perspective. Someone might read it that way, but I think, we have a 6-state New England grid. The carbon reduction benefit that's been calculated for the project is calculated on the back down of conventional generation across the grid. So I think the 1.5 million tons a year of CO2 that we avoid accrues to the benefit of the whole region, regardless of who happens to be doing the scorekeeping. Right.
No, I think I was referring to the method used by Mass DEP in terms of how they do the carbon inventories. And if I'm not mistaken, I think if a renewable energy source has a bilateral contract to an entity in another state, they get the credit for the carbon offset. Although, as you're pointing out, it affects the entire grid. So, there's an accounting versus kind of practical dimensions element, or at least a contradiction, perhaps. Would you see it that way?
I think it's a conundrum, though.
Good word. Anyway, putting aside the accounting minutia, there is a consequence, obviously, of delay in terms of delayed carbon benefits, and whether it's Massachusetts' attainment of a goal or another state or the entire region, it is a detriment, at least in a macro sense, right?
Definitely, and I think there's sort of another element of this is, although the combined government and private sector have been trying to advance the industry for the better, in earnest for 5 years now. The construction of the first project, Vineyard Wind 1, is just now on the horizon, and I think there's some real merit to trying to build on that momentum. So to have the next project and the next project proceed on as efficient a schedule as possible, I think sends a good signal to everybody else involved that folks are really serious about moving this forward. So I think that's a point to be kept in mind as well.
So let me just ask another, sort of hypothetical question about balancing or weighing the trade-offs between the benefits that we've just talked about of speedier project development, earlier realization of benefits, both financial and environmental, versus the sort of risk that led to the standard of Cape Wind and Vineyard Wind 1 in the first place, which was, if to paraphrase, the concern about the construction of a transmission line to nowhere. The sort of notion that, well, what if they start building, they meaning Vineyard Wind, start building a line, incurring environmental impacts to build the line, and then for whatever reason, the project never comes to fruition, a la Cape Wind, let's say. So, trading off the sort of concern about impacts without a project being developed successfully versus the benefits of flexibility and speedier construction. How would you compare those two considerations in terms of which should be the more dominant concern for the siting board as a matter of precedent and policy making?
So I think I understand how this came into being in significant measure out of the Cape Wind experience, and a lot of really good and smart people worked really hard on that project on all sides of it. A great deal of money was spent, and unfortunately, it didn't have the outcome that folks hoped for. But it was also a long time ago, and I think there is far more momentum behind building a viable offshore wind industry now, far more buy-in at every level, strong leadership at the federal level, strong leadership at the state level. There's enthusiasm at the local level. So I do think we're talking about a different point in history, and I personally would like to see us err on the side of keeping things moving, building some momentum. And I think the risk that truly significant work gets done and is never used is very small at this point.
And when you say the risk is very small, you didn't say zero, but I'm wondering if it's close to zero.
Well, engineers are trained never to say zero, but I would say it's pretty damn close. So
I would agree with Mr. Martin, because we're talking, I think we're primarily talking about onshore works here and duck bank within pre-existing roadways for the most of it. So the likelihood of that work occurring and not being utilized by someone, if it wasn't this project, even though it will be this project, is very unlikely that infrastructure would not be utilized.
This gets back to the earlier questions about BOEM's jurisdiction, but would BOEM allow jet plowing in state waters in advance of the record of decision, or would they regard that as core to their jurisdiction and necessitating a final record of decision? Again, in state waters, not federal waters.
I'll defer to others, but I think it would be highly unlikely that any offshore cable installation would occur without having all of your permits in hand, both state and federal, since that's usually a continuous operation within the time of year restrictions you're allowed to work in, that it'd be unlikely that you would start a campaign without having all your permits on the offshore portion. But others may feel differently on that one.
I would agree that as a practical matter, unlike onshore, you don't install segments in the same manner. But I think from BOEM's perspective, I think they, and this partly gets back to the easement that's granted under the lease from the federal government, that certainly within the area that is under the easement granted by the federal government, that no activity could occur. So I agree with Mr. Arruda.
So if the siting board were reevaluating what the correct standard is for a demonstration of an offshore wind project that is likely to contribute to the regional energy supply. Let me just ask, A, would it make sense to distinguish between what it might allow prior to the record of decision in the onshore theater versus the offshore theater? That's part A. And part B would be, if not the record of decision, what other milestone or indication of project robustness or likelihood would you point to as perhaps a better marker than the final record of decision?
Well, I think one clear area that would provide some indication of the likelihood of the final federal approval would be approval of the final environmental impact statement as a significant marker. And given the difference in, at least in this at this stage of federal permitting compared to how it had progressed under the previous administration, approval of a draft environmental impact statement would also provide a fair amount of, I think, a strong indication of how things are progressing at the federal level. And as I mentioned earlier, you know, from our communications with BOEM recently, they are, you know, working on multiple COPs now simultaneously. They've incorporated a lot of the experience and the benefits of the Vineyard Wind 1 project, including the supplemental EIS, and that I think that, along with the federal policy starting at President Biden's level, every indication is that things are intended to move forward on the permitting milestones that are set out, and that as we hit the draft environmental impact statement and final environmental impact statement, those should provide some pretty good signals as to the final project approval at the federal side.
So recognizing that it's very difficult to predict when BOEM does certain things, but can you give an idea, a rough idea, what the sort of timing is between the issuance of the draft environmental impact statement by BOEM, the final environmental impact statement by BOEM, and the record of decision? So if we picked and something other than the record of decision as that milestone, how much are we speeding up the process in a sort of average expectation?
So that well, they just, as I think we all know, they just published the notice of intent, which is the signal that they've completed their initial review of the COP. They found it sufficient to enter the public piece of the NEPA process. So the DEIS is about a year out, and that actually, if everything goes as we hope, that lines up pretty well with the completion of the state, regional, and hopefully the local permitting. So I think if you had all those things ready at that point, you'd have a pretty good assurance that the project will get the rest of the way through the federal process, and you could use that as a benchmark for some limited state jurisdictional work.
And I could say on the the federal permitting milestone website, I believe the current dates are that the notice of availability of the draft EIS is August 2022, and notice of availability of the final EIS is June 2023. And the issuance of the ROD is July 23rd, 2023.
So it would be almost a year prior to the record of decision if we use the DEIS as that marker of progress or likelihood of project success.
I think it'd be 11 months of about 11 months.
And would that provide a significant benefit in terms of the environmental and economic factors that we were discussing previously?
Well, I think at this point we're not we haven't gotten to that stage of scheduling, but to know that there was a period of time up to that amount, that would allow us to schedule early stage work, coordinated work with the town of Barnstable, and have everything sequenced around the various permitting limitations that we expect, as well as limiting local impacts. I think that would give some very welcome flexibility to try to make things as streamlined and as quick as possible.
And I would add, Mr. Green, to your questions about the importance of having flexibility, just to go back, it's the onshore works is one of the critical components of this whole offshore wind farm to make sure that it's built on time, on schedule, because without the grid interconnection and the ability to backfeed to the offshore substation and the rest of the wind farm, it's very difficult to progress construction if you are delayed on your grid connection to the wind farm. So any flexibility, whatever that milestone that gets determined to use, is helpful to the project because of the criticality of the onshore schedule. And as Mr. Rodstrom's pointed out, there are elements of the onshore works that are yet to be defined in coordination with the town. So depending on what the town decides they would like to do in conjunction with our project, those all take time. That integration is very tedious. Schedule integration can be difficult. So you just want to make sure that you leave yourself some flexibility in this overall schedule to make that all come together without jeopardizing the project schedule overall.
So I think I'm, discerning what the company's viewpoint is about this notion of an alternative milestone marker, but I'm wondering whether, frankly, the company would like to take it offline, think about this in a more rigorous manner, and perhaps suggest an alternative standard to the one that the board has used in Vineyard Wind 1 and Cape Wind, and submit that for the record, or whether you'd like the testimony today to serve as the company's viewpoint that is in the record. Maybe that's a question for Mr. Khan or other counsel.
The company would appreciate an opportunity in a record response to define periods prior to the record of decision in which construction is acceptable to the siting board, I guess.
And if I could just put a little bit of a finer point on that, again, distinguish between what types of construction might happen prior to the record of decision and which types of construction would have to wait for the record of decision for either legal reasons or other reasons, which is something we also explored today. I would like to make that a record request then, if it's the company's interest in responding to that.
Yes, thank you.
Mr. Wong, I am sorry for the interruption.
You're fine.
Before we move on, just for the record, that's record request EFSB 10.
Mr. Hazel has a record request as well.
Thank you. Mr. Rodstrom, it sounded like you were almost reading off a sheet of dates from the federal permitting timeline or something like that. Is that a a published schedule that you would be able to provide to the board?
Yes, it's a published schedule that we can definitely provide to the board. Yeah.
All right.
Excuse me. I didn't mean to interrupt.
Go ahead.
No, I was just going to say it's a published schedule of federal permitting milestones.
And I assume that document must be updated periodically.
It is updated by the Fast 41 program staff, but I think the objective is to set those milestones now at the time that the NOI is issued, or just prior, and then adhere to them. So, but you are correct. They do get updated on the federal side.
Okay. Well, I'd like to ask a record request for the permitting timeline that you just referred to. Is there a proper title for it so that I can reference it correctly?
I believe it's called the Federal Permitting Dashboard, and it's part of the Fast 41 program.
Okay. So I'd like to ask a record request for the permitting schedule that Mr. Rodstrom just described on the record.
That would be record request EFSB 11.
Mr. Rodstrom, thank you for thank everyone for their answers. Fast 41, is that the Fixing America's Surface Transportation Act? Is that FAST?
Yes, I believe that was the legislation that created that program under, I believe it was the Obama administration.
Thank you. So we covered a lot of ground in the past hour. I have some questions that might have a might slightly be related, but mostly I hope to have them differentiated. So, Mr. Rodstrom, you provided the updated dates that the company expects the ROD, the DEIS, the FEIS to come out. And this is coming in at the same question from a different angle. As of right now, do these timelines line up with when the company intended to begin its construction? Because I understand the requirement for flexibility, but is this still within the company's expectation of when it can start construction?
Yeah, I think it's largely in keeping with what we had expected. I think early on we had imagined a record of decision being issued 2 years after the notice of intent is issued for the draft environmental impact statement. That's largely held true. There are many pieces that also go into that, plus associated federal permits. But we do think that this is largely in keeping with the project from its early stage.
Thank you. And we've talked a lot about what comes before the ROD. Could you briefly state what permits must follow after the ROD, and would this further hold up starting of offshore construction?
Sure, and I should say I use the acronym FAST 41, but the actual federal agency or council is the Federal Permitting Improvement Steering Council, also known as FIPSI, and that is the federal entity created under FAST 41 to track federal permitting progress and milestones and coordinate among federal agencies. So just to clarify that acronym. But to your point, when the record of, essentially the way I understand it is when BOEM approves the project by issuing a record of decision, that is an indication to BOEM to issue an approved COP, as well as to other federal agencies to issue associated permits that are required, including Army Corps of Engineers, EPA, and so on. So so the record of decision essentially says that BOEM has completed its evaluation under NEPA. It finds the findings are set forth, and that it proceeds on to the issuance of the approved COP and approved permits from other agencies. And that's what happened. That's what follows soon thereafter.
Okay.
and it's generally within 2 or 3 months after the ROD.
Got it. I understand that the company is going to work on this answer in their record request, but never mind. I think the company will work on this in the record request. Yeah, that's fair. So if I could refer the company to the analysis at pages 2-5 to 2-7, where they list all of the, well, let me know if this is an exhaustive list of all the significant indicators for the project in order to show that it will likely be available. I'll give you some time to get there. But we've talked about the BOEM part, that bullet point a lot. I want the company to walk through all the bullet points and provide any updates you might have about the process of those. If for example, there's a point about the PURA and was intended to be filed last year, and whether that's been filed and so on and so forth.
So this is the list starting on page 2-5, right?
Yep.
Okay. So I can start this, and I'm sure my colleagues will want to add some thoughts as well. So we have updated some elements of this in the course of a few of the the discovery requests, but at this point, the lease piece of it was done when this was written. Similarly, the site assessment plan was done, and we've been engaged in extensive data collection ever since. That continued into this season. We've been working hard with the town of Barnstable on the HCA for the second project. The second project, as you know, was contemplated in the first HCA, but we're now working with them on an HCA that is specific to the second project. We're confident that will conclude reasonably soon. Everybody's been working hard on that. The Connecticut award is obviously behind us. The power purchase contracts with the utilities have been finalized, and we did address that in one of the discovery requests, and I believe provided a copy of the contracts. On the federal process, we've been talking about some of the efforts there. But the COP, as it said here, was filed basically a year ago. With the new administration coming in, the whole process has gotten back on track. We got our NOI on June 30th. As Chris mentioned earlier, I believe the public comment hearings, the scoping hearings basically for the DEIS are scheduled for this coming week. The first one is on the 19th. There are 3 remote hearings scheduled. BOEM has published on the permitting dashboard the schedule for the entire federal review process. And then the one federal decision, which was a Trump administration executive order, has been superseded by the use of the Fast 41 process. So I think those are the key items. And then to add to that, since this list was generated, we've completed the first 2 steps of the MEPA review. So we just got the scope for the FEIR 2 or 3 weeks ago. We've started to work on that already. We've obviously reached a big milestone with EFSB, and the hearings are underway. We have already begun some early preparations for some of the regional filings. So now we're making good headway on the state, regional, and local sequence. I think those are kind of the high points, but others may want to add to that.
I would just add that the long-term power purchase agreement was finalized in August 2020, and it was filed under response EFSB-N-2. In addition, as I had mentioned earlier, one significant milestone, although it's not, it wasn't conditioned on this, but it was the completion of the Vineyard Wind 1 lease segregation, so that the assignment of the offshore wind lease, formerly 501, now 532, to Vineyard Wind for this project was also completed.
And you would suggest that that's a significant indicator that this project will be available, because could you explain that more? Just for the record. Yeah, thank you.
Well, I think it's important because it demonstrates, as with many things with Vineyard Wind, we're doing things for the first time. And the process, which was always anticipated, of a lease providing multiple offshore wind projects to be built within a single lease area, thus necessitating or often requiring a segregation of portions of the lease area into separate leases. That was always contemplated, but actually having that completed for Vineyard Wind 1 and establishing the new lease number and assignment of the remainder of the lease area under 530, lease area 534, I think is a significant milestone, because at the end of the project for Vineyard Wind Connector 2, we anticipate the same process would be required, where the offshore wind lease area would be segmented, and that the phase 2 project at some point in the future would be within its own lease. So that mechanism, while anticipated, was took a lot of legal work on both the BOEM side and our side, but it was successful.
Okay. Thank you. Earlier this afternoon, we talked about the risk tolerance for the company, and I think, does the company also have its own internal list of significant indicators that would sort of inform its risk, whether it's risk averse or risk, like, if, I don't know if this makes sense. So we're looking at this list of significant indicators that is purportedly going to tell us whether we believe that this project's going to go forward. And the company sounds like they also have a list that they probably have to go through it in order to decide if there's a risk in moving forward to the next step. Is this list provided in the petition pretty similar to that, or does the company have more indicators that it uses?
I could start off. I think that the company certainly looks at the list that we've been discussing as being, containing a critical list, or a kind of central list of milestones that need to be met to continue to move the project forward. I would say augmenting that are the additional work being done at a a finer level on the type of survey, engineering, electrical design study that I would say better characterize it. They further refine the final project design and the financial aspects, the supply chain and procurement, and refined schedule. So I think it's not as much kind of broad milestones that we're talking about with this list, but a kind of a further refined milestones that provide greater certainty and de-risking the project and being able to optimize the final design of what's built and operated.
Thank
And
you. That
I
sorry.
might add one milestone to that the project definitely looks at, and that's its grid interconnection. And the fact that we completed our system impact study, we received our I-39 approval from the ISO back in January of this year. So, and we're just working to finalizing our large generator interconnect agreement with the ISO and Eversource at this time. So those are also milestones that the project would look at, having a completed interconnection approval.
Thank you. While we're on the topic of significant indicators of project, and I think Mr. Aruda and Mr. Rostrom, when you touch on when you talk about the design and the grid interconnection, that sort of links me to the work at the West Barnstable substation. Do you see that as a significant indicator of progress, whether that particular piece of, not part of this project, but whether those works, whether that proceeds, does that sort of inform the company's approach to whether this is risk escalating or de-escalating?
Could you clarify just a little bit for me when you say that work at West Barnstable proceeds?
Yeah, so at the moment, there isn't a proposal anywhere as far as we know that the West Barnstable substation is going to be built. I know it's being talked about and discussed, but if that isn't permitted, where is this project going is my question.
Are you referring to the Eversource West Barnstable substation?
Yes, so.
I think Mr. Wong is asking about, like, to what extent are the substation upgrades at West Barnstable critical path and, you know, a significant indicator of progress for Vineyard Wind 2?
The upgrades at the West Barnstable substation are part of the requirements for the project to interconnect to the regional transmission system. So they have to proceed, and they are proceeding, you know, as we speak, that process. The actual construction of that will flow through our whole schedule that we work out with Eversource. As part of our large generator interconnect agreement, we'll capture those milestones in there for proceeding forward with those individual build out of the substation.
Got it. And apologies for the question not coming out exactly in a cogent way. This might not be tell me if this question isn't for the company. Do you know if the West Barnstable substation, those upgrades would have to go through any federal process since it's part of this project in some way?
I'm not aware of a federal process for that interconnection process. Most of the interconnection process I'm familiar with and work through is the ISO New England process, which ultimately is governed, you know, by the FERC tariff, but it's dealt with through the ISO New England interconnect process. I would defer to our legal folks or the Eversource folks, whether there's a federal element to this that I'm not aware of beyond the ISO process.
I think earlier today we, you know, briefly talked about the concept that the BOEM's record of decision and the whole, federal review of Vineyard Wind 2 is not just the offshore part of the project, but it really captures the entire project. And I guess at some point when you're connecting to a regional transmission system, you have to draw a line and say the project stops here. So is it, are the upgrades at West Barnstable substation captured in any of the company's, project, reviews with BOEM or with any other federal agencies that are looking at the totality of this Vineyard Wind 2?
And just to clarify, Mr. Aruda, I believe Mr. Hazel is talking about Eversource's West Barnstable substation.
Correct. I'll defer to some of my colleagues here, but it's my understanding that the BOEM jurisdiction does not include the West Barnstable substation, which is part of the ISO New England Regional Transmission System. But if I'm incorrect, please, one of my colleagues chime in.
No, I believe Mr. Aruda is correct that the Vineyard Wind South COP does identify the West Barnstable substation as the point of interconnection for the project, but does not include the evaluation or permitting of the same under that.
Thank you.
Thank you. Ms. Sharkey, well, I have a couple more questions. Do you know when you want to take the next break?
We can take it now, or we can take it in the conclusion of your questions. Until there's a good break in your questioning. If it's a good time to take a break, we can take it now.
I think I'll ask one more question and then we can go on a break. So as part of the company's description for need, it talks about the general support that such a project has in the Commonwealth. Has the company looked at recently passed legislation from after the filing, such as Senate Bill 9, and whether there's anything in those, and also the Climate Roadmap 2040, 2050 legislations? Is there anything that the company has reviewed, and is there language in those pieces of legislation that would help to bolster the company's case that projects like these are supported in the Commonwealth?
Let's see, the company's was definitely aware of and read through and was very, and I personally was very encouraged by the legislation and the governor's roadmap, and it certainly, I think it's an acceleration and a greater indication of the urgency of the need to transition to a clean energy future and adopt renewable energy, as well as many other steps in response to climate change and to grow our economy and build a green economy. So I think some of the language of that, of those that legislation and the governor's direction are in keeping with the need that this project is helping to meet, and would just augment, I think, what we've already stated.
Thank you, Mr. Rostrom. Nothing further. Sorry?
I would just add, if it's helpful to EFSB staff, that our response to EFSB G29 did address the project's consistency with that climate roadmap.
Thank you, Ms. Johnston. Nothing further on that right now.
Does that mean you'd like to take a break now, Mr. Wallin?
Oh, Mr. Green.
Mr.
So
Green,
one follow-up question before I lose it. And I just wanted to ask the company whether the siting board standard of review for an interconnection to offshore wind should differ based on whether the off-taker, i.e. the customer of the wind energy and other attributes, is in Massachusetts, in another New England state, or outside of New England, such as perhaps New York, all of which are probably able to be served by a project in the Rhode Island, Massachusetts wind area. So is there any reason for the siting board to have a different standard of review for an interconnection line based on where the ultimate customer is that's buying the energy and other attributes? In terms of, again, need and likely indicators of project progress, that segueing back to my earlier line of questions. Should we amend that to the record request?
Well, I think that may be useful. I would just say that, the overall, the New England states, in particular Massachusetts, Rhode Island, Connecticut, are in particular are facing similar threats from climate change, are implementing similarly ambitious laws and policies to address that, including a acceleration of renewable energy and offshore wind adoption. And so I think both the reasons for part of the reasons for those policy changes, as well as the kind of the regional nature of the response and the general kind of regional response and kind of collective response to that need, would suggest to me that it's not necessarily an issue that's parsed along a state jurisdictional boundary, but much like ISO New England connects all the New England states in a regional electric grid, with all benefiting and all contributing and all responsible for it. Similarly, transitioning that electric power supply to one with renewable energy as opposed to fossil fuels is a regional effort implemented by state laws in each of the states, but it's still in a manner a collective effort in response to a shared threat.
So your answer is no.
That's kind of a long, I think, a long-winded way of saying that. Yes.
Okay, thank you.
well, why don't I give it a separate record request number? And as record request EFSB 12, ask the company whether the siting board's standard of review for an interconnection to offshore wind should differ basis on the location of the ultimate consumers receiving the power from the facility.
That's right. Thank you.
And are we ready to take our break now, or are there any further questions before we do that? Mr. Wong? In that case, we'll take a 15-minute break, Mr. Brock.
Yes, that's good. Thank you.
Thank you. And we'll be back in 15 minutes. Stop. Go.
Donna, I was wondering if we could talk about that before we go on the record and see if
Sure.
maybe that makes sense.
Sure. In light, you mean in terms of whether interveners have questions that they
Yeah.
want to ask today or not?
Yeah. That'll help with the pacing, I think.
Okay.
I just caught the end of that. Could you repeat what you were saying?
I said Alan's going to ask all the questions for the rest of the day.
Okay, well, with that, we're finished for the day.
Originally we had anticipated we were going to go beyond need, but I pointed out to Wayne, the interveners may well have questions on the topic of need, and it's basically usually better to do it in the day you started a topic than hold off to a future hearing date. So when we come back, Wayne does have some more, but I will ask the interveners if they have questions on what we've asked so far today.
Got it. Thank you.
Donna, is your expectation, will we get to the other topics at all today, or are those going to be shifted? Or maybe you've decided you don't need any question?
Yeah, yes, highly unlikely for anything that we do, that we don't have any questions. No, what I'm going to ask the interveners if they have any questions on the topics we've covered so far today. Any answers we get will probably determine on whether we will move on to some of the issues Joanna was going to cover today. Okay, before we go back on the record, I was wondering if I could hear from intervener counsel as to whether they had any questions that they would like to ask on what we've asked so far today. And you can think about it if you need to, while Mr. Wong wraps up his questions on need. I can't hear you, Mr. Eugenio, sorry. I still can't hear you.
Testing 1, 2, 3.
And now I can hear you. It's the magic word testing.
The microphone switches back and forth. Sorry. Yeah, I'm Jeff Eugenio. I represent Mark Axelson. Mark owns property at 861 Craigville Beach Road. As I understand, the board's scope for today is need, cost, project alternatives, route selection. As I understand, we've been primarily focused on need. We do have some questions to ask. Understanding we want to keep some efficiency here. Is that we do have some questions. Do you want me to focus it on only need and save the others, or in the interest of efficiency? I don't think I will take that long to go through what I have on all the topics.
Yeah, I think we would, my plan, I think, as I said earlier, a long time ago in the morning, was that if we, we'd allow people to follow up and try and wrap up a specific topic if we could, just because it's easier in terms of both where it appears in the record on the transcript, and because people sometimes lose their questions or what they wanted to ask if it gets deferred to, another day. So if it's possible and you have questions on need or anything else that was asked today,
Sure.
We'd like to wrap those up when we go back on the record. If it's on route selection or things that were or project approach, which were scheduled for today, but that we haven't started, then we will start with those topics on Monday. And just kind of follow along in the order of topics, even if they are different from the days that were originally identified in the schedule.
Yeah, so we'll just keep flowing.
And-
it won't be continued to another day and beyond Monday.
Oh,
We'll
well,
get a separate day. I wasn't sure whether you'd stop today's proceeding and go with scheduled witnesses for Monday's already scheduled topics, but we would just keep going, continue this hearing through Monday, as you said.
yes, thank you, Mr. Rosenzweig.
That's why I was going to interject as well. I do believe that we may be able to have these same witnesses available on Monday because it's a pretty similar panel, but that won't necessarily always be the case. So
I understand, and if there's a scheduling conflict that you're anticipating, please let me know.
are we expecting to have this same, are we still off the record?
We are still off the record.
Are we expecting to require the same panel for Monday?
I believe we would expect to have the same panel because they were designated for all of the topics that were originally designated for today. Is that correct?
That's right. I think that on Monday, we have a slightly different lineup that we had coordinated schedules for. So I think Holly perhaps wasn't necessarily scheduled to be on Monday. And Jack Aruda was also not scheduled to be on Monday. So I don't mean to put my own witnesses on the spot for their availability. But
Speaking for myself, Zach, I'm available on Monday, but I believe Chris may have a conflict.
And this would be for an additional day because that had originally been scheduled and then it was not included on the revised schedule, and now they're proposing to put it back on.
No, we're scheduled to go. Our next day of hearings is scheduled for Monday. Because we have not yet reached route selection or project approach that were scheduled for today, I'm anticipating that we would start with those on Monday. If there are witnesses who were scheduled to speak on those two topics who would not be available on Monday, then someone should let me know.
Mr. Rostrom, we had sent an incorrect schedule before that omitted Monday, but Monday is still on the schedule. I think Ms. Downish also wants to say something.
I don't know if it's appropriate. You can correct me. My clients informed me that there's work already going on at the Shoe Flying Road location, and I'm just curious if anybody knows if that's just Eversource doing something or if the project's already started over there.
I'd be happy to respond if it's appropriate.
Sure, we're still off the record, Mr. Rodstrom, but you're still
Okay.
under oath.
Yeah, so there's no construction work occurring on any portion of the project anywhere. We are doing some due diligence surveys of various properties, so including doing some geotechnical surveys and archaeological assessments, but those are only temporary in nature and only in order to inform permitting.
Ms. Cuthan, do you know if Eversource has any activities which are whether or not they're related to the project that are going on in that area?
I know that they don't have any activities going on with respect to the projects. I do not know without checking whether there are any other activities such as, routine maintenance or anything like that.
I could add that I know for the Barnstable Reliability Project, they were installing the double circuit tower separation tower. So the new tower just south of the Chute Flying Hill Road property within the Eversource right-of-way. But that was entirely within the, just from what I had observed, that was entirely within the Eversource transmission right-of-way. But that was fairly recent, so.
I don't think we got to hear whether Ms. Dalmas has any questions for Need late if we asked for them today.
I'm good. It was only just one observation, and it came out of the discussions about, project milestones, and I was just curious.
Okay.
Well, once Mr. Wong wraps up, then we will open it up to you and to Mr. Eugenio, and just so you have an opportunity to actually follow up on the same day the initial testimony was given.
And I guess Eversource is an intervener. Do they have to say if they want to ask questions or?
Ms. Cuthan, do you have any follow-up questions you wish to ask today?
I have no questions on behalf of Eversource on Need.
Thank you.
Thank you.
Okay, Mr. Brock, could we go back on the record?
Okay. In the company's response to EFSB N-6, the company talked about the forward capacity auction 17. Here are some questions related to that. For the record, could the company state when FCA 17 is going to happen and what that is going to be? Sorry, just when is that going to happen?
FTA 17 would be in February of 2023. FCA 16 is next February, meaning 2022. So 17 would be 23. You're asking about the actual auction, when the actual auction takes place. Yes.
Thank you. And so according to that response, the company is currently evaluating whether to participate in it. I was wondering if the witnesses could explain what obligations a project would have if they were successful in participating in the FCA.
If you the forward capacity auctions take place 3 years prior to the obligation period at which you are to deliver your capacity, should you receive an obligation in the auction. So the project, if it was to participate in FCA 17, take on an obligation for the 26-27 timeframe, which starts on June 1st, 2026, then you are obligated to meet that capacity supply obligation that you've committed to. If you cannot meet it, then you have to try to shed that obligation through annual reconfiguration auctions or bilateral agreements. So it's a risk. You do put up a fair amount of financial assurance depending on the obligation you receive. So it's a decision the project will make as the schedules progress here and the confidence level that the project would meet a June 1st, 2026 COD as to whether it would truly, participate in that auction or not.
Thank you, Mr. Ruda. And for the record, could you explain a little bit about the mechanism behind, because correct me if I'm wrong, all of the megawatts for this project are contracted to the Connecticut bidding situation, does that take precedence over a commitment to the FCA? How does that work? Or is there some sort of, give and take on both ends?
Well, there's two different things we're talking about here. There's energy and capacity. The capacity is a separate market, and the capacity is the mechanism for truing up the capacity with EDCs is built into the PPA structure.
I'm sorry, the mechanism for truing up the capacity for
the EDCs.
Thank you. For the EDCs is what?
Is captured in the PPA structure.
Thank you.
Thank you. That clarification was important. Moving on. The electrical grid in the Commonwealth and New England in general is summer peaking. Is that correct?
I would say that's correct. As of now, it's still based on the summer peak, and that's how the capacity markets are structured on your summer capability.
Thank you. And could you explain, because the company does talk a little bit about wintertime reliability, could you explain why wintertime electric reliability is a concern now or maybe sometime in the future for the Commonwealth and New England?
I can start on it, and my colleagues can chime in at any point here. But as you mentioned prior, right now, ISO New England still is considered a summer peak system. But as we've all experienced, and as Mr. Barton spoke to earlier today, the winter is becoming more and more prevalent as a reliability issue because of the constrained natural gas that we have in New England. And since the majority of the conventional generation is natural gas, it's a balance between producing power during those cold winter days when the heat load is at its peak. And that is actually when offshore wind will be at its peak. So there's a good synergy here with the ability for offshore wind to offset the need for fossil generation.
So what you're saying is that the benefit of this project for wintertime reliability isn't just a future benefit whenever the grid might turn into a wintertime peaking grid. It's currently going to be helpful as well.
Yes, because I think when we're saying it's still a summer peak, that's how the ISO system focuses on the capacity clearing. But as we've all seen over the last several years, the winter peak loads can be significant now. And yes, the benefits will be from day one when this project comes online for its ability to offset the need for conventional fossil generation during those winter months.
Thank you. Mr. Ruda, you had said maybe another colleague would want to supplement that. Does anyone else have anything to add?
I think Mr. Aruta's comments covered it. In case it is helpful to EFSB staff, we do cover this item in the petition as well, but the DEIR in terms it's folded into the discussion of benefits, and specifically at the bottom of page 1-17. As Mr. Aruta was describing, this project will reduce winter energy price spikes, essentially by freeing up natural gas resources necessary for home heating demands.
Thank you, Ms. Johnston. That's really helpful. Finally, the company has described also in that section the reliability benefit of this project to the electrical grid locally in southeastern Massachusetts. I'd like to delve into that claim a little bit more. Could you explain the basis of this claim, given that is it really that local, or is it really a regional benefit? I can add more if you need more clarification. For example, the company has stated that because so many big generators are going offline in that area, that this project will come in and supplement that. But those big generators aren't necessarily just serving southeastern Massachusetts. Could you talk about whether the statement that this project improves reliability of electrical grid in southeastern Massachusetts is the right flavor of that statement?
I think that statement, as we wrote it, is correct, and it was attempting to convey that good high capacity factor offshore wind immediately off the Cape, with transmission being brought onto the Cape and fed into the Cape part of the grid, basically strengthens or bolsters the reliability of that part of the system. And that statement was made with the backdrop that many of the traditional or conventional utility plants in that area have been retired, or in the case of something like the older canal units, are used very sporadically. Now, how fine a point you want to put on it as far as, is that a benefit for only the Cape and southeastern Massachusetts, or does it help reliability a little further out on the grid? You could certainly have that discussion, but we were trying to convey that some homegrown power, if you will, helps the situation on the Cape and southeastern Massachusetts.
Thank you. Mr. Barton, you said we could have that discussion if we wanted. Could we have a little bit of that discussion here about the local versus the regional benefits? Because I think it's clear that it's going to benefit locally, but could you talk about how it does in fact benefit region? I mean, and it's probably, if it's discussed elsewhere in the petition, feel free to bring up that page. But I kind of want also to know about the reliability for all of New England, for example.
Okay, I don't think we've addressed this in any specific form elsewhere in the documents, but just to illustrate it with somewhat of a hypothetical, say at a point where you have both Vineyard Wind 1 and Vineyard Wind 2 built, and they're operating at something close to full capacity on a cold, windy winter day, you'd be making as much as 1,600 megawatts, injecting it into the grid at Barnstable and West Barnstable on a day when the load on the Cape might be 300 megawatts, 400 megawatts. So clearly there's a lot of power that would, on a day like that, would be moving off the Cape and into the system in southeastern Massachusetts. How far that goes and how far you can continue that argument, I'm not really sure, but it clearly on a day like that would have some benefit for the broader southeastern Massachusetts part of the grid.
Thank you, Mr. Barton. I think I'm all set with that. Anyone else on the panel? I mean, anyone else on the bench have anything to ask about me before I move on to interveners?
In that case, Mr. Eugenio, would you have some questions you'd like to ask the witnesses today?
I do.
Thank you.
Can you hear me well?
I can.
Okay, thank you. I do have a few questions on behalf of Mr. Axelson. I just want to just preface a few of my questions by, we're just trying to do the best we can to keep our questions within the scope of what I understand is the board's mandate under Chapter 164, Section 69H, to when considering such projects, to when encouraging such projects, that they focus on providing a reliable energy supply for the Commonwealth with a minimum impact on the environment at the lowest possible cost, which is where I understand the board's mandate to be. So I'll try to focus on need. I just have a few questions, and most of them are just follow-ups on things we've heard earlier today. I think it was Mr. Barton. Of course, any of the panel can answer any of these questions, but I think Mr. Barton spoke earlier today about the idea of shared transmission versus generator lead, and how to get that power on shore. And I think it was him that spoke a little bit about it. In Europe, is their sites are a little bit further ahead in adopting the shared transmission, which, as I understand it, is a more streamlined route to get the power on shore, versus as I understand it, to be termed a generator lead means to go, where you're using, for lack of a better term, a bunch of separate cables to go on shore. I guess as it relates to need, or as it relates to your earlier testimony, when the best way to do it in an ideal world, in an ideal situation, to adopt a shared transmission route to take the power from the farms onto shore. As I understand, that was not able to be done here. And if you could elaborate on that a little bit, I'd appreciate it.
Okay, well, I think it was actually Mr. Rodstrom added the color commentary on the European experience, but nonetheless, what the company has proposed and has approved for Vineyard Wind 1, and what we are proposing for Vineyard Wind 2, in our minds is definitely the best and the most straightforward way to get that as much as 1,600 megawatts onto shore and plugged into the regional grid at Barnstable and at West Barnstable. And some of the reasons why that works is that we're not all that far offshore, 40 miles, 35 miles to the south coast of the Cape. We have very sizable substations to plug into 4 or 5 miles to the north of that. They can accept the capacity with minimal upgrades to the grid. And we can do that basically between the two projects using 4 AC cables, 400 megawatts each, placed in a fairly tight pattern in a well-studied export cable corridor. So in many ways, the cabling doesn't look all that different than what you would have under a shared transmission concept going to the same substations, but we're able to do it using AC cable without the additional, and in this case, unnecessary expense of an HVDC system. So an HVDC system would use for this power, you'd have to have 2 cable systems, but you'd also need HVDC conversion stations at either end, which are very substantial and very expensive installations. So while there could be a scenario in the future where shared transmission makes sense for parts of the wind industry as a whole, we feel the solution we have proposed is the one that best balances that siting board mandate of efficiency, cost, and environmental impact.
The primary consideration is cost, and are there any environmental trade-offs between the two?
Well, we're trying to achieve a balance, and in this case, the balance is a very reliable, cost-effective, and a system that has minimal impacts. So we think we have the right answer for this. I'll leave it at that.
And beyond cost, I might add that schedule is a big impact too, because schedule the big, large converter stations, which Mr. Barton's referring to, have several year lead time on getting those large converter stations built and delivered on top of the additional costs for them.
In terms of environmental impact, I would just add that those large converter stations are on both ends of the DC system. So you would have additional onshore impacts and offshore impacts. And in the case of the project we're proposing now, the routing is very direct. So it's essentially the shortest possible route, where the shared transmission system, that may not be the case.
Thank you. And I don't know that this relates directly to need, but I think it was Mr. Rodstrom that testified earlier on some of the geotechnical work that had been done already, that there were some surveys. We talked about some archaeological surveys, some indigenous people surveys. Has there anything been found thus far? My client's primary interest is he owns property abutting Covell's Beach, which is, as you know, is the variant one option. Has there been anything found thus far which would indicate that the Craigville Beach, the primary landing site, would not be used?
Speaking to Craigville Beach, there were geotechnical surveys done this summer, or earlier this summer. And those, I think the results of those studies are helping us refine the design, but there was nothing that was determined to prevent the cable from making landfall at Craigville Beach.
Okay. Just hate to take it back to Europe again. I think Mr. Rostrom, you mentioned European technology having been a couple decades ahead of that in the United States. Are there any advancements or lessons that have been learned there which would be applied to this project? And how does this, and in that sense, how does this project compare in size to some of the major projects in Europe, if you know?
Well, I think the industry as a whole globally is advancing, where larger turbines and improved methods are being advanced kind of across the board and being implemented with projects that are kind of in sync in time. But of course, Europe has had decades of experience actually designing, building, and operating wind farms. So I think they've got a lot more experience in what are the long-term implications of offshore wind benefits. How do the predicted impacts actually play out over time as they're monitored? So I think their experience has been to be able to better understand projects over their lifespan. But I think as far as technologies and for instance, turbine sizes, those are being implemented kind of globally as a global market. I would say, though, to your earlier point, and when I was alluding to Europe and the shared transmission, Europe does have one very notable lesson from the shared transmission experience, where I believe it was Germany, where they had and I should say most of the projects, from what I understand, are generator lead line there. But that there was a notable example where a shared transmission development was out of sync. It did not get built in time to interconnect an offshore wind farm that stood idle for a period of time, and it really demonstrated some of the risks that we've been talking about having a separate transmission project from the offshore wind generation project. And so I think it was a kind of a telling lesson of some of the risks of that approach.
As to the size of this project versus some in Europe, I know in some of the literature, I think it's Copenhagen Infrastructure Partners had been involved, at least in the financing. it appeared with I think it was a 900 megawatt project in Germany, the Wind 3, I believe it was called. I don't know if anyone's familiar with that, and just how does the scope of, I guess, Vineyard Wind 2 along with Vineyard Wind 1 compare to that or the other projects that the owners have undertaken in the past?
I think in general, offshore wind farms have been getting larger and more efficient and with a greater capacity factor. I don't have the specifics on that one project, but I think that's been the general trend.
And I think I just have one more question that would relate to need, and I don't know if this may be a question for the panel, maybe a question for council even. Just going back to the board's mandate to encourage reliable energy source for the Commonwealth, and we've touched on it a couple times today. It appears that Connecticut has procured all the power for this particular phase, or for Vineyard Wind 2. How does that relate to the board's mandate to provide a reliable energy supply for the Commonwealth of Massachusetts and not necessarily Connecticut?
Presiding officer. I think there's a record request almost identical to Mr. Ugino's question. And if my memory is right, I'd suggest that we wait for that answer.
To the extent the company does not want to respond at this point and wants to rely on the response it will be providing in the record request, could the company identify the record request to which they are referring?
Just give me 1 second. I apologize if there does not appear to be a record request. It was simply discussed earlier.
Mr. Eugenio, would you like to make a record request with a specific question for the company to provide a written response to? And your mic is out again, I'm sorry.
Testing 1, 2, 3. Hear me?
There you go.
My apologies. I would, in that case, I'd like the record request just to be
Your mic is cutting out again, Mr. Eugenio. Sorry.
how do you hear me now?
Now I can hear.
If council would be so kind, the record request to be how, in light of the statutory mandate under 69H, that the board encourage a reliable energy supply for the Commonwealth of Massachusetts, how the procurement by Connecticut of all the power from this Vineyard 2 phase, Vineyard Wind 2 phase meets that objective.
Okay, that will be record request MAT-1.
Thank you. And that's all I have for today. Thanks.
Ms. Dalamas?
No questions for today. Thank you.
I'm sorry, I can't hear you, Ms. Dalmas.
Hear me now?
No.
Okay, how's that? Yeah.
It sounds like you're in a windy room.
Or that it's up against your heart or something. There's some beating in the background.
Is that a bit better? No?
We can hear you at least. Do you have a question you'd like to ask?
No, I'm good for today. Thank you.
Okay. All right then. Mr. Khan, do you have anything you would like to do in terms of redirect today? Or Mr. Gerson, sorry.
Unless Mr. Gerson has something, I don't. Apologies, we can't whisper together.
I was waiting for Adam to say that before I jumped in with turning down the opportunity, but I don't have it.
Okay, then given, does anyone have an appetite to begin route selection or project approach, or would they like to wait until 10 o'clock on Monday?
Donna, we had a very small topic of cost scheduled for today, and I could definitely do that before 5 o'clock. So
Then
that might be a compromise.
That would be wonderful. Thank you, Mr. Hazel.
Okay. I'd like the company to refer to, I believe it's attachment L to volume 2 of the initial filing. And I need to get there myself. My basic question is, the company provided a table that shows cost differentials between the primary route and the other kind of noticed options for this project. And I appreciate that these are, confidential cost estimates, and the company's extended these differentials to us as sort of a middle ground. But I'm wanting to know whether the company has assigned a level of accuracy to the cost estimates that these differentials correspond to.
Just a moment, please. I've got a technical issue. Oh, sorry.
Well, I could
wait. Just a moment, please. I've got to get my technical issue resolved first.
Ms. Sharkey, before we go back on the record, later, after everything, after the questions, could we confirm whether we have a panel on Monday or not?
Thank you, Mr. Wang.
All right, we're back on. Sorry about that.
Thank you, Mr. Brock. So I believe the Mr. Hazel had a question pending upon the degree of certainty or at least potential range of the cost estimates that were provided by the company in table L-1.
So we
I
actually,
do- Go ahead, Mr. Martin.
I was just going to say, we actually addressed that in the response to information request EFSB C-1. And we basically explained that at the point that attachment was put together, we were relying on concept level estimates, essentially a plus or minus 50% figure.
I'm sorry, essentially plus or minus what?
50%. 50.
So I think in Vineyard Wind 1, there's a limited discussion of cost, and the company sort of said, given the level of accuracy of the cost estimates, these two numbers are actually quite similar to one another. And I was wondering if the company could offer a similar characterization of the difference between the preferred route and the noticed alternative route, given the plus or minus 50% level of accuracy associated with the differentials.
So I think just to start that, and my colleagues might want to chime in, to the effect that we're basically using a unit cost. The unit cost for the work on the preferred route versus the unit cost on the road portions of the noticed alternative are going to be similar. So therefore, the difference would arise mainly from the difference in length.
I guess my question is really more about like given the certainty of the cost estimates, concept level estimates, which you indicated were plus or minus 50% accuracy. Does that still imply that there's a significant cost difference between the primary and the noticed alternative route, kind of given the margin of error on the cost estimates, or does the company view those as significantly different from one another, even considering the cost, even considering the accuracy?
So I unfortunately do not have that exhibit in front of me. So I don't know if one of my colleagues who does can address it a little more accurately, but what I said a few minutes ago, I think still holds, that to the extent there's a difference, it would arise out of a difference in length, because at that level, you wouldn't assign one unit price to the preferred route and some totally different unit price to the noticed alternative, even though you're working with concept level numbers.
Mr. Martin, this is John Young, also from the panel, or joining the panel if I could. You said you had 50 plus or minus 50 on each of the alternatives. Can you estimate, since you say it's mostly a matter of the distance of the two routes, could you give a plus or minus on the differential? Is that also plus or minus 50, or is that larger or smaller?
I'm not sure I follow that question exactly, but what I was attempting to convey is that and again, I'm trying to do this without that exhibit in front of me, that the difference that we should be thinking about is the difference that stems from any difference in length between the two alternatives.
Well, so I think you would be saying that it's not realistic for one one of the routes to turn out to be plus 50 and the other one to end up minus 50, correct?
That's a fair way to put it.
And if I could add to that, just I think Ted is Mr. Barton is getting that exactly right. Some of the significant more complex and costly features such as the landfall, the crossing of the Centerville River, crossing of Route 6, those are similar between many of the alternatives, and that it's the length and the location of the duct bank, whether it's in road or in right of way, and the portion of or the distance of the different routes that are the primary driver of the cost differences.
So I was wondering if the cost differential between the routes, if everything else is similar, and it's depending on just the length of them and stuff like that, whether that would be proportional. So if you had a plus or minus 50 on the total cost, whether a proportional bit that's just, you have a factor being the length of the route, does that mean that your differential would be something like plus or minus 50 proportionally to the uncertainty of the estimate of the total cost? If you had a super simplified version of the cost estimate, you might have a cost per mile that's plus or minus 50% and a mileage which is plus or minus nothing, because that would be a firm number. And so then if you had 1/10 of a mile difference between the two, then you'd be multiplying that by your cost per mile, which has a uncertainty of plus or minus 50. I mean, that's very simplistic because I'm neglecting all other kinds of costs in there.
I'm sorry, all other kinds of what?
I'm neglecting all other kinds of costs in there, but I'm simplistically thinking that the cost differential might have the same plus or minus 50 as the underlying cost estimate. And I wonder if that was true.
If you're working with concept level estimates at that accuracy to start with, if you take a difference between the two, I would still assign the same uncertainty then to the difference.
Okay, thank you.
My final question on this topic was again related to the substation design modification, and Mr. Rodstrom indicated that part of the reason for lowering the overall grade is to try and optimize the amount of fill you need to either bring into the site or take away from the site. Is it correct that importing or exporting large amounts of fill has, large cost implications?
Certainly importing fill has large cost implications. There may be some value in exported fill, as clean material could have some value. So I think there is a slight difference in the economics of importing versus exporting.
And if by lowering the grade, you're basically avoiding the need to import fill, so would that lower the capital cost of constructing the substation?
I think it would have the advantage of reducing the capital costs if you do not have to import fill, and also would have significant benefits in reducing truck traffic to the site. Yes.
Has the company worked out how much less expensive it would be for this more recent design variant of the substation to lower the elevation and avoid the cost of importing fill?
I think we have a general understanding of the, general market cost of X cubic yards of fill, but we haven't done a detailed assessment of that. But I think it's fair to say it would certainly be advantageous to reduce or eliminate the need for fill being brought on site.
I guess I'm not super familiar with how construction cost estimating works, but I am interested in the idea of like a cost differential between the original substation design and then the new substation design. Just a differential between those two. Would that be possible for the company to estimate that cost difference, cost savings?
Just to clarify, on the overall substation cost or just the cost of civil site preparation?
Either, yeah. Since I'm just interested in the differential, I guess it wouldn't really matter if it was the differential on site prep or the differential on the total construction, the total substation development.
Mr. Hazel, would you want to add in also the purchase of the triangular piece as that is tied to the differential, the price of the substation with the new design?
I hadn't considered that, but yeah, I mean, I understanding that the board takes a lighter look at cost of, privately funded lot projects or whatever, but I guess I'll just phrase it as a record request and the company can figure out how it wants to reply to it. I would like a cost differential between the substation design submitted in the DEIR and the substation design submitted in Exhibit VW10. It would be great if that cost differential reflected the acquisition of the property and also any costs avoided by, not importing fill or, changing the overall site prep work.
I'm sorry, changing the overall site, what?
Site preparation work.
That would be record request EFSB -13. Also, Mr. Rodstrom, I thought I had read that the company was planning to acquire the parcel from the Chamber of Commerce for $1. Is that correct?
I could clarify that the Commonwealth had retained a right to purchase the property for $1 if offered for sale. But the Vineyard Wind has entered into an agreement to purchase the property from the Chamber of Commerce for market value.
Thank you for clarifying that.
That's all the questions I have on cost.
Does anyone else have any follow-up questions on cost?
I have a few, if I may. On behalf of
Mr. Eugenio?
This is to anyone on the panel. In looking at the landfall site options that were laid out, it looked like there were, I think, 51 different sites. Just by their identity, it appears that most of these are public landing sites. I guess my first question in this regard is there a reason that public landing sites may or may not necessarily be a cheaper option to make landfall versus buying someone's private land or buying an easement on private land? And I guess secondly, in that regard, was that a strategy that was followed here? That is it an objective to ordinarily seek landfall at public sites versus private sites, either with Vineyard Wind here, or even if that's a customary customary goal in the industry.
So I am just pulling up a section of our analysis, which I think will be helpful here. And it's section 4.3.3 of our analysis. It begins on page 4-7. So this is exhibit VW-1. This section discusses our assessment of potential landfall sites. And you're right, there were approximately 50 initially assessed. It goes through the number of criteria we used to assess the viability of landfall sites. For necessary purpose, for obvious reasons, we favored beachfront areas with clear egress onto hopefully public roadways, sites with enough space to accommodate HDD, so a trenchless transition from offshore to onshore, and this usually means about a half an acre of area. Ideally, a paved area is very helpful because it reduces impacts from HDD staging and the HDD operations themselves. We're very cognizant that we're working in a coastal environment where there are overlapping wetland resource areas. So working in, say, a paved town parking lot helps reduce a lot of potential construction impacts. It's fairly rare to find a large paved surface on a private property, maybe something like a private beach club, but we have found it helpful to be working in paved public parking lots, such as at Covell's Beach or at Craigville Public Beach, which is the preferred landfall site for this project. Not sure if any of my fellow panelists have anything to add there. I believe part of your question also pertains to cost. The differences between use of a public landfall site versus private landfall site in terms of cost would be entirely dependent on the particular situation. A public site, I'm sorry, a private property for a landfall site would likely mean acquisition of property rights there. Use of a public site, in our experience, has dovetailed into a host community agreement, which obviously also pertains to other portions of the project that may be located in the same municipality.
Understanding your answer, and I understand the variables, and I'll take it that your answer is that a lot of the variables that you look for selection criteria lend themselves to public landfall sites. In mentioning acquisition cost, is it, and I know this is stating a generality, but is part of the strategy in finding sites? I mean, you got the 51 list of 51 came from somewhere. Is monetary cost part of that in choosing public sites, or is it more of a practical concern, as you mentioned, acquisition cost, if you will, and the other factors versus the geotechnical or on the ground physical factors?
Sure. Cost was not specifically a criterion that we used in initially identifying potentially feasible landfall sites. Rather, it was the list of criteria on pages 4-7 and 4-8 of our analysis.
Is it customary, as I think you mentioned, that public landfall sites may lend themselves to host community agreements in the given community?
I'm sorry, was that a question? I think I missed the first part of it.
Sure. Is it customary or even a strategy here that choosing a public landfall site would lend itself to a potential host community agreement?
Whether it's customary or not, I can't necessarily speak to. Certainly in this particular circumstance, Vineyard Wind has been working closely with the town of Barnstable. The host community agreement for Vineyard Wind Connector 1 did envision a second project.
I'm sorry, the host community agreement for Vineyard Connector 1, what?
Did envision a second project. So there is already kind of a framework host community agreement in place for the Vineyard Wind Connector 2. Mr. Rodstrom, I'm not sure if you want to provide any updates on the status of that. But.
Well, I think I would expand on that, and I think to the question, the factors that Ms. Johnston had described, I think can also be looked at with the landfall being evaluated together with the onshore transmission route, and with the landfall being publicly owned and the onshore transmission route being public roads, and that being evaluated and ultimately, the decision and the approval is made by the town of Barnstable to assent to that, but that it allows us to work together with the town to look at both landfall and routing together, which I think has some additional advantages. So I think to your question, a public beach parking lot landfall does have that additional advantage of looking at both the publicly owned road route as well as a landfall site.
Mr. Eugenio, we can't hear you.
One, two, three. Okay.
Yes.
I'm all done. Thank you very much for your answers.
Does anyone else have questions? In that case, does the company have any redirect on cost?
We do not.
In that case, I believe we need to just verify who is going to be present at the hearing on Monday before we close for today. So will the panel be able to be available on Monday at 10 to deal with the other issues that were scheduled originally for today?
We have in between that, well, we're seeking to confirm what we can do for Mr. Rodstrom, who had I think the carryover of today has created an issue where he is more needed on Monday than the original schedule would have called for. So Mr. Barton, Maria Hartnett, AJ Jablanowski will be here. I don't know if Mr. Rodstrom has been able to identify a portion of the day when he could be available. And I'm sorry doing this way, but I don't have another way to do it.
No pressure, Mr. Rodstrom.
No, and I do apologize. I had been working off the version of the schedule that had actually dropped Monday off. So this is entirely my doing. And did have another an engagement I committed to, and so that's what I've been trying to furiously work around as I realized that Monday was actually a scheduled day.
Ms. Starkey, would we mind going off the record for this conversation?
Certainly, off the record.
Thank you.
So I've been working as we've been holding the last couple of hours hearing of trying to find a time. I am going to be hard pressed to be able to join by Zoom. And I don't know if or if I did, I would be kind of on the road. So I don't know if that's at all appropriate for, an hour of the proceedings, but I could certainly make myself available in the morning to do that.
Does the company have a concern that it would be compromised in its ability to respond on those questions, on those topics on Monday? If Mr. Rodstrom is unable to participate? We could, of course, if there are questions which he might specifically need to respond to, then note that and defer those to a subsequent day where he is available.
So, Ms. Sharkey, that's exactly what I was going to suggest. I do think that Ms. Johnston and Mr. Barton will be available on Monday, and if we want to start at 10, we haven't had a full chance to run this by them, but I believe that they will be available in the morning if we wanted to start with these topics. So we will get the majority of this panel on Monday. And then we will have plenty of time with Mr. Rodstrom over the next month. And if there are items that call for his special expertise, I think we could identify them then.
Thank you. We appreciate the company's help in dealing with the schedule issues. Mr. Brock, can we go back on the record so I can announce that we will resume Monday at 10 o'clock? Thank you, Mr. Brock. We are convened for today. Thank you. See everybody on Monday morning.
Thank you.
Good weekend, everyone.
You.